Is there anything?
Take my earrings off. Sorry, baby. I was trying to break it to you earlier.
Thank you. Good morning, everyone. Just quickly, over the weekend, we added some additional boxes, of additional folders to Box. So within, and also shared links to those folders with everyone. So under pre-filed testimony and exhibits, within each party's folder, there is now a new main folder called Shared. And within that folder are subfolders for cross-examination exhibits and stipulated exhibits. These folders should be utilized to move documents that you want to share with the parties prior to them being admitted into the record. Once they're admitted into the record, then they would be moved into the admitted folder. So we just wanted to go over that briefly, and if anybody has any questions, I'm available now to answer them.
Hey, Carmen, it's Andrea Harper. How are
Hey,
you?
Andrea.
Anything that you sent over the weekend, I haven't been able to get into. I'm still having that issue.
Okay, I will get the links to you this morning, Andrea.
Thank you so much. I appreciate it.
No problem.
And so, Carmen, to be clear, we should put in all the pre-filed exhibit. This is Anjali, by the way, from OPC. The exhibits that we filed on Saturday as part of our cross list, that's what you want us to put in that box?
Correct.
Okay, thank you.
You're welcome.
I'm sorry, this is Brian Caldwell, DC government. I just joined. I missed what she said. What box we're supposed to put across the bit?
It's okay. Good morning, Brian.
Good morning.
Over the weekend, we added some new folders to the pre-filed folder, main folder. Now in everybody's main pre-filed folder, there's a new folder called Shared, and there are subfolders within that folder titled Stipulated Exhibits and Cross-Examination Exhibits. Those folders should be utilized to place documents, exhibits, stipulated exhibits, and cross-examination exhibits that you want to share with the parties prior to those documents being admitted into the record. So it's just like a middle ground for sharing with the parties prior to anything being admitted into the record. And those folders are shared with all of the parties. So that main shared folder, everyone has access to that folder.
Okay, got it. Thank you.
Okay, you're welcome, Brian.
Carmen, it's Dennis Chamino. Can you hear me okay?
Yes, hi Dennis, good morning.
Good morning. Just so I'm clear, we have a lot of the exhibits in there that are public testimonies, our testimonies actually for the entire case. Is what you're saying that we need to move those to the shared folder?
If Kim is on the line, if she could clarify that, let me see. If we can wait for Kim to join so that she can answer that question, Dennis.
Yeah, sure. Because right now we have them in the folders, and within Pepco there are several folders. One of them is testimony and exhibits, and so that's where we kind of had placed them for now. So that's the question. Thank you.
Okay, you're welcome. And the stenographer has a few instructions that he wants to go over with everyone. I'm going to unmute him now. Mr. Dunn, if you could please share the instructions that you just shared with me with everyone on the call. Mr. Dunn?
Yes.
Okay.
I'm going to need to know who's going to be the main questioners, and also this has a lag time and speaking on top of each other, which is hard for anybody not to do. I can only take down what I hear, and what these systems do, whoever's speaking that's who it stays with. So if 2 or 3 people are talking, it only stays with one, and there's not. I can only take what I hear.
Okay, so to answer your first question, let me mute you. To answer your first question, the chairman is the moderator of the evidentiary hearing, and all of the parties will announce themselves as they speak and ask questions amongst each other.
Perfect.
Okay. To answer the second question, I guess if everyone can just take note of that and try to give a little bit of a pause, you know, as you before you start speaking, so that the lag time can catch up with the stenographer. Is that all that you need, sir?
That's pretty much it. And if there's any acronyms or anything that comes up, if they could give those to me whenever they happen to come up. I have some information, but you know, all governments seem to have different acronyms for different things, and I don't know anything about this case. So,
Okay, sounds good. I will make sure that you have the names of everyone who speaks on this call today. Okay,
perfect. Thank you so much.
you're welcome.
And then just let me know when to go on the record.
Okay, when the chairman commences the session, then you can start the record.
Carmen, this is Fran Francis speaking. My question is there a place for us to like raise our hand? How do we make the point that we have something to say when somebody's speaking? Is there a button that I press, or do I just raise my hand?
Brenda, if you can confirm, but I think that you will have to unmute yourself and object, Fran.
I believe that is correct.
We have to be cognizant of that, of objections.
Okay, so just unmute it and say, this is Fran Francis, I have something to say.
Yes,
Thank you.
you're welcome. And while I'm on the line, may I please remind everyone, when you're not speaking, it is critical that you mute yourself. We've got to cut down on as much background noise as we can. So just please please mute yourself when you're not speaking. Thank you.
Hey, Carmen, this is Kevin Carey with AOVA. You said you sent something over the weekend, links to boxes. I didn't receive anything. I'm not sure if Fran had received it as well.
For box, sir?
Yes.
Okay, I will take your name down and I'll re-forward you the links, okay?
Okay, thanks so much. Sorry about that.
Okay, no problem.
Carmen, this is Brian Caldwell again with the TC government. My witness, Courtney Lane, she's scheduled, I think, to testify on Wednesday. And she hadn't received a WebEx link. Is she going to get that Wednesday morning or when?
Correct. Yes. Okay. So everyone can expect to receive the WebEx links either the evening prior or the morning of the hearing. It will be before 9 a.m. each day.
Okay, so she is on the list of people to receive a link then.
Correct, Brian.
Thank you so much. Appreciate that.
You're welcome. No problem.
And I guess since we have all the parties or most of the parties on the line, is the plan to stick to the schedule of witnesses that Pepco circulated last week? In other words, we're not gonna. I'm just curious if there's a possibility that my witness may go on Tuesday instead of Wednesday when she's currently scheduled.
Brian, oh, I'm
I'm
sorry.
sorry.
This is Fran. I don't know if you got the email. There were certain witnesses that I said I didn't have cross-examination for. I sent it to Pepco. Yesterday, there were 3, and I have very little for today. So, just based on my time, we may finish. It's possible we could finish depending on what everybody else has before Wednesday. Did you get my email yesterday about the 3 witnesses that I wasn't crossing?
I'm not sure, but I know for like Pepco's witnesses, there's probably a little more flexibility between, if they go on Tuesday or Monday, but like for other parties' witnesses, I don't know if maybe I guess this is a question for Pepco, if the plan is to just do all the other parties' witnesses on Wednesday.
Okay, everyone. As there are no more questions for the Secretary's office regarding box, I'm just letting everyone know we will start shortly. Thank you.
Hey,
Bye-bye.
And
sorry.
also, if I could ask, I'm going to unmute a telephone caller with the area code 571. We need to know who you are. Hello? Telephone caller beginning with 571. The last 2 digits are 34. Can you please state your name?
Hi, Carmen, can you hear me?
Yes.
This is Kathy.
Hi, Kathy. How are you?
Good, how are you?
Good. So, just FYI, joining by telephone does not allow you to participate in the confidential breakout sessions. So if you need to hear or desire to hear the information that's being discussed in the confidential breakout room, you will need to join via computer.
Okay, yeah, no, I wasn't going to participate in the confidential session, so that's fine.
Okay. All right. Thank you, Kathy.
Carmen, this is Fran. I'm not sure I understand what these confidential breakout rooms are.
So, as you know, everything is virtual, and we're trying as best as possible to replicate the environment that it would be if we were in the hearing room. So when we move to the confidential portion of cross-examination or testimony or anything, we will move to a private breakout room that will not be streamed to the public. So it will allow us to have the confidential discussion privately.
Hey, Carmen.
Yes.
Sorry, it's Andrea. I just want to make sure you would like on the WebEx only the cross-examiner, the witness, and the attorney, and everybody else should watch the live stream. Is that what you guys would like?
Correct.
And will the live, I'm sorry, I talked over you. Will the live stream link be where you often get it in this October 26 box on the homepage?
On the calendar, yes.
Okay. Okay, so it'll change pretty soon from procedural schedule to a link?
It should be there now. If you could refresh your screen, please.
It sure did. Okay, thanks so much.
Okay, you're welcome.
Okay. But Carmen, this is Fran. I have someone on the phone who will be showing the documents for me. That's all right if he stays on, isn't it? He will be pulling up my documents.
I'm sorry, I'm not sure what you're asking, friend. There's somebody on the call right now.
Kevin Carey.
Oh yeah, Kevin. Yeah, he's fine. Yes.
Okay, that's all.
Okay. Everyone, please mute your line.
Good morning, everyone. And I know this is redundant, but I'm reaching out again just to ensure that everyone understands the importance of muting yourself when you're not speaking. Please be conscious of this throughout the hearing. Thank you.
Chairman Phillips, you need to unmute your mic. Can you hear me? Chairman Phillips, you need to unmute your mic. Your microphone is still muted, Chairman.
In that regard. So let me try again. Good morning, ladies and gentlemen. For the record, today is October 26, 2020. My name is Willie L. Phillips, and I'm chairman of the Public Service Commission of the District of Columbia. Commissioner Richard Beverly is also joining this hearing virtually today. I'm going to call to order this virtual evidentiary hearing in the matter before us, which is formal case number 1156, in the matter of the application of Potomac Electric Power Company for authority to implement a multi-year rate plan for electric distribution service in the District of Columbia. This evidentiary hearing is being held to address Pepco's rate case increase application. As way of background, on May 30th, 2019, Pepco filed an application requesting authority to increase the existing distribution rates by $147 million through the implementation of a multi-year rate plan, or MRP, for the years 2020 through 2022. On June 1, 2020, in response to order number 20349, Pepco filed an MRP enhanced proposal, an alternative to the original MRP proposal. Pepco represents that if fully approved as filed, the original MRP proposal would translate to an increase in distribution rates of approximately $8.21 in 2020, $3.84 in 2021, and $3.41 in 2022 for a residential standard office service customer who uses 692 kilowatt hours per month, which is typical customer usage. Pepco also represents that, if fully approved, the MRP enhanced proposal with certain rate offsets should result in an increase in distribution rates of approximately $0 in 2020, $0 in 2021, and $7.97 in 2022 for a typical residential SOS customer. Should the Commission reject Pepco's original MRP proposal and the MRP enhanced proposal, Pepco's application includes a traditional rate case that requests, if fully approved, an increase in base distribution rates of approximately $77 million, resulting in an increase of approximately $7.92 for a typical residential SOS customer. Under the DC Code Section 34-1504D2, the Commission can only approve Pepco's MRP as an alternative form of regulation if the Commission finds the MRP A, protects consumers, B, ensures the quality, availability, and reliability of Pepco's electric services, and C, is in the interest of the public, including shareholders of the electric company. As you are aware, the Commission has been focusing on streamlining our proceedings to make them more administratively efficient. This is a goal that I've had as chairman. Accordingly, on September 24, 2020, by order number 20632, the Commission directed the parties to prepare a joint list of material issues of fact and dispute in an effort to aid the Commission in determining whether an evidentiary hearing was necessary. The parties were to A, identify with specificity material issues of disputed facts, B, set forth the parties' stipulations, C, indicate the number of witnesses as well as the nature of their testimony in the joint witness cross-examination matrix, D, provide admissions, E, authenticate documents, and F, address any other procedural matters. On October 16, 2020, the parties filed a joint response to order number 20362, identifying over 372 issues that they claim are material issues of fact and dispute. Although we believe that the vast majority of the parties' enumerated issues of fact are policy or legal issues that don't require a hearing, I acknowledge all parties concerned that this is the first time that the Commission will be addressing alternative forms of rate making and that it is in the public interest to hold this hearing. However, in an effort to streamline the hearing, the Commission will accept the party stipulations noted in the joint response. In addition, the Commission will accept in the record the deposition transcript of Pepco witness Mr. McGowan, which the parties previously stipulated to. The parties have indicated and designated times needed for cross-examination of the witnesses, and I intend to hold the parties to their represented time limits. We're going to start the hearing based on the issues you cite for cross-examination for the witnesses. For the first witness, Mr. McGowan, OPC, AOBA, and DCG represent that they need 40 minutes and Lyona needs 20 minutes to conduct cross-examination on the traditional test period, original MRP, MRP enhanced proposals, customer benefits, district's energy policy goals, performance incentive mechanisms or PIMs, and COVID-19 impacts of Pepco's proposals. After the parties conduct their cross-examination of Mr. McGowan, the Commission may also have questions. For Pepco witness Wolverton, OPC and AOBA need 40 minutes. DCG needs 30 minutes to cross-examine the witness on original MRP and MRP enhanced proposals, revenue requirements and rate-making designs, reconciliation processes, MRP escalation rate, and the COVID-19 impacts on Pepco's proposals. In the event that we finish with the first two witnesses today, we'll just continue calling witnesses and allowing the identified times for cross-examination and the issues noted in the parties' file. At this time, I'm going to ask the parties if they would identify themselves for the record, starting with Pepco, and then the People's Councils, and then the interveners in alphabetical order. And to avoid the mistake that I just made, Pepco, you may want to unmute your microphone.
Who is speaking on behalf of Pepco?
Do we have Pepco on the line? Commissioner Secretary?
Pepco is on the line.
I'm sorry, I had an additional mute button.
Thank you.
So the headsets have a mute button. I'm getting educated. My apologies. Good morning. My name is Kim Hassan, and I am the Associate General Counsel here at Pepco Holdings. In addition, we will have additional counsel who will be speaking throughout the day, and we provided that information to the Secretary. Would the Commission like me to present those names of the presenters now or as they become available?
Yes, Kim, identify them, please.
Thank you. Andrea Harper will be speaking, as well as Dennis Jamino. And we also have outside counsel who will be presenting.
I'm having trouble with my audio. Everybody, please hold on one moment. We'll take a quick moment.
Maybe we should add some intermission music.
I can hum.
I'll join you.
I'll get it. Hey, turn that light back on.
All right, we hear you now.
Okay. The company was identifying themselves for the record. Please proceed.
Okay. And Pepco mentioned that, I'll just start over if it's easier. Kim Hassan, Andrea Harper, Dennis Jamino. And we have outside counsel who have filed motions for special appearance before the commission. That includes Colette Honorable from Reed Smith, Sherry Bellamy,
Hello?
We can hear you, sir.
Is Pepco finished?
I think
They are, sir.
can you hear me? Okay, and I think I finished with Dennis Jamino and our outside counsel who have filed motions for special appearance. That includes Colette Honorable from Reed Smith, Sherry Bellamy from Parker Poe, and Nicholas Penn from Parker Poe. And that is it for Pepco. Thank you.
Thank you. People's Counsel.
Good morning, Chairman Phillips, Commissioner Beverly. I'm Anjali Patel, lead counsel on behalf of the Office of the People's Counsel for the District of Columbia. I'm appearing on behalf of the People's Counsel, Sandra Madhavu Fry, Also appearing are key members of OPC's directorate and staff, including Deputy People's Counsel Karen Sistrunk, Litigation Director Lawrence Daniels, and Assistant People's Counsels Adrian Mouton Henderson and Tim Oberleiten. Additionally appearing on behalf of the office are outside counsel Scott Strauss and Amanda Drennan from the law firm of Spiegel and McDermott, Jason Gray from the law firm of Duncan and Allen, Kevin Conaseni and John Adragna from the law firm of McCarter and English, and Pavitha Modi and Kristen McConnelly McCullough from the law firm of Duncan Weinberg, Genser and Pembroke. If the chairman and Commissioner Beverly would permit, I would like to read into the record a short statement on behalf of the People's Council.
If you would hold off, because that's an opening statement.
Good morning, Your Honor. I am Fran G. Francis. It is nice to see the commission, even if it's just on camera. My name is Fran, middle initial G. Francis. I am Senior Vice President and General Counsel of the Apartment and Office Building Association. I will be the one speaking for AOBA, an acronym, all capitals, AOBA for the court reporter. I would also like to enter the appearance of Etcetral K. Caldwell and Nicola Y. Whiteman. However, I will be the only one speaking till my witness, Bruce R. Oliver, takes the witness stand at the appropriate time. Your Honor, AOBA, like OPC, also has an opening statement I would like to make at the appropriate time, as well as a preliminary matter that I've previously discussed with counsel, the General Counsel of the Commission. Thank you.
Thank you, Ms. Francis. I believe we have district government.
Yes, thank you. Good morning, Commissioner Phillips and Commissioner Beverly. My name is Brian Caldwell. I am an Assistant Attorney General with the Office of the Attorney General for the District of Columbia. I'm here today representing the District of Columbia government. Thank you.
Next, we have DC Wassa.
Good morning. Michael Engelman with the law firm of Engelman Fallon PLLC on behalf of DC Water.
Thank you. We have GSA.
Good morning. This is Christy Singleton, Assistant General Counsel, appearing on behalf of the General Services Administration.
All right, the International Brotherhood of Electric Workers. We have the Lyona.
Brian Petruska. I'm General Counsel for the Lyuna Mid-Atlantic Regional Organizing Coalition, and I am sole counsel for Baltimore Washington Laborers District Council.
All right, next we have Maryland, DC, Virginia Solar Energy Industry Association.
Yeah, good morning, Chairman and Commissioner Beverly. My name is Eric Wallace with the law firm Green Locker on behalf of the Maryland, DC, Delaware, Virginia Solar Energy Industries Association, or MDVCIA.
Okay, so you're going to have to repeat. You froze and then a lot of cutting out.
Okay, good morning. My name is Eric Wallace with the law firm Green Locker. It's GREENEHURLOCKER on behalf of the Maryland, DC, Delaware, Virginia Solar Energy Industries Association, or MDVCIA.
Welcome, Mr. Wallace. Small Business Advocates. Is anyone on SBA? Next, we have Washington Gas. Anyone on for Washington Gas? If you're speaking, you're on mute.
I think Washington Gas phoned in, sir, but they were on the line earlier.
All right, we will identify them when they appear. Have I missed any parties that need to identify themselves? All right. This being a formal evidentiary hearing, I'm advising the parties that pursuant to section 134.1 of the Commission's Rules of Practice and Procedure, the federal rules of evidence will be applied to this hearing with regard to the submission of evidence. Because there may be some discussion regarding confidential information, the parties need to advise the bench when they propose to discuss any confidential information. So I can assure that only persons who have signed the appropriate confidentiality agreement are present. When we go into confidential session, we will pause the live stream and only permit access to the virtual hearing to those authorized parties, and we'll provide an approximate time for which parties may be granted access again. At this hearing, evidence shall be presented in the following order: Pepco's entire case, OPC's entire case, and each intervener's entire case in alphabetical order, as we just stated. Also, the parties will cross-examine other parties' witnesses in the following order: Pepco, OPC, and the interveners in alphabetical order. Finally, all parties must ensure that their audio remains muted until recognized to speak. Parties have asked about opening statements. We would ask that if the parties have opening statements, if they submit their statements for the record to the Secretary's office in the interest of time, so that we may get started immediately with cross-examination. Are there any questions or preliminary matters to discuss before the hearing begins, such as availability of witnesses, last-minute scheduling issues, or whether any parties anticipate raising an objection or making a motion once the evidentiary hearing begins?
Your Honor, this is Fran Francis. Can you hear me?
Yes, you recognize.
Yes, we may make some motions during the course of the hearings as different witnesses are introduced. We are prepared also to respond to other motions that other parties may make. When we submitted our time schedule for the commission to reserve time for who we may have cross-examination for, we submitted that approximately 10 days ago. During that time, AOBA has significantly cut down its cross, and we will not be needing all of the time that we previously noted on that list. We informed counsel for Pepco yesterday that there were 3 additional witnesses that we were willing not to cross-examine. And as Pepco witnesses are presented, we will determine how much time we need, if any, for those witnesses. We spent the last week reviewing the testimony and our position. That said, we do have a motion that I sent an email to all parties. We would like to make a motion pursuant to Rule 132.4 and ask for a modification in the briefing schedule. What we are asking for is to have one brief, which would be due on December 18th. In the alternative, we are asking for a delay in the briefing schedule, where one brief would be submitted December 9th. The reply brief would be submitted December 23rd. I sent all parties an email. GSA, OPC, DC government all support this motion. Pepco does not. I have not heard from the other parties, but as grounds in support of the motion, I would like to state the following. When the parties determined the procedural schedule, which was adopted by this commission in December of 2019, order number 20273, the parties were given 8 weeks for briefing and 2 weeks for reply brief. Then again, on August 9th, in order number 2024, that continued. The parties had 8 weeks for briefing, 2 weeks for reply brief. Again, on February 5th, in order number 20293, the parties were given 8 weeks for briefing and 2 weeks for reply briefs. And somehow, on June 18th, in order number 20368, which was also carried into the July 8th order number 20375, the parties' briefing was cut to 4 weeks and 2 weeks. However, since that time, since the time of the July 8th order, there has been additional testimony filed by all parties on July 27th. The parties also had Pepco's various filings that occurred between July 24th, July 28th, July 31st of testimony and errata, significant volumes of testimony. There was also a technical conference as well as more testimony that was filed on October 9th and October 14th. I think everybody is aware, as the commission stated, we now have two significant MRPs in front of us, both substantially different. We also have the traditional test year in front of us. We have the summer filings as well as all of the testimony that we have not addressed before. Pepco has filed 8 versions of testimony, each hundreds, if not thousands of pages. It is an enormous record, and I submit that the parties could use a full 10 weeks of briefing for scheduling. That is why we would agree, and we think it's preferable to have one brief and to have all parties submit their positions and their arguments in that one brief. In the alternative, we are asking for a briefing schedule that would allow 6 weeks for the initial brief and 2 weeks for a reply brief. Thank you, Your Honor.
Thank you, Ms. Francis. Any response from the company? You're speaking, I can't hear you. Does Pepco want to speak to the motion?
Yes, sir. We're trying to get off mute right now. One second.
I'm familiar with the issue.
What's going on? Can you hear me now?
We can hear you.
Video now. No.
Please identify yourself for the record.
This is Sherry Bellamy on behalf of Pepco, and I am sorry, sir, that something seems to be going wrong with the video. Brian, someone, please. Can you hear me?
We can hear you.
All right, let me just speak. Pepco does not agree with the other parties that this should be condensed into one brief. And the commission has already addressed this in order number 20204, in which they said that, quote, at paragraph 36, the elimination of the short period added to the schedule for a reply brief will not reduce the regulatory lag or streamline the commission's proceeding to any significant extent. The consolidation into one brief would be of de minimis benefit, if at all. On the other hand, the commission went on to say that allowing the opportunity for reply briefs would crystallize the issues of all the parties and allow each party to speak to the opinions of or the positions of the opposing parties. But I'd add another point to this discussion, which is that unlike the the parties proposing this consolidation into one brief, Pepco has the burden of proof. Pepco, therefore, should be given the opportunity, as is traditionally given, to speak to the arguments of all of the other parties, all the interveners, as well as OPC. In addition to that, to shorten the time frame with which Pepco would have to reply would be unfair and prejudicial to us. in the sense that every other party has one target to address, and we have multiple targets with different issues of importance to each one of them. It's going to take a considerable amount of time for us to consolidate and review the initial briefs of all of the parties. We think that the schedule the commission has already adopted in Order 20632 is reasonable, and we'd ask that that schedule be kept in place. This proceeding has gone on for approximately 18 months now, and extending it further does not seem to be of benefit to anyone, but certainly foreshortening the time that Pepco has to respond as appropriate to all the other parties would be of detriment to us. So that's our position of companies.
Your Honor, AOBA did not shorten the time. It's Fran Francis. AOBA did not shorten the time that Pepco had because we extended the schedule. We extended the schedule to December 23rd from December 18th. That should not delay too much. And the intention was not to cut Pepco's date short. I would like to remind the commission that the date that is set now is the day after Thanksgiving. Many offices are closed. There is also a federal holiday in there. And I forgot to say to begin with, when we set this schedule, the parties and the commission were very mindful of other proceedings before this commission. During this next month, as this commission is well aware, we have hearings scheduled in the $35 million rate request by Washington Gas. Those hearings are scheduled for the middle of November. We also have briefs to prepare in that proceeding, which is also scheduled during that time. Some of the parties' resources can't handle all of that and do the job that needs to be done in this proceeding on behalf of ratepayers. It is a very difficult schedule to meet, and this commission has enormous cases before it right at the moment, between Washington Gas's case for the rate increase as well as the Project Pipes $374 million case. And this case, AOBA has done everything we can to meet every schedule. The way this is now, it just is not practical or doable. Thank you, Your Honor.
If I could respond, please, Your Honor. This is Sherry Bellamy again. Why is this thing cutting out on me? If I could respond, please, Your Honor.
1 minute. You have 1 minute to respond.
Yes, a quick response. My understanding of the schedule in order number 20632 is that we had from November 27th to the filing of the initial post-hearing brief and December 18th for the filing of the reply brief. That was 3 weeks, not 2 weeks, in my estimation, as I look at the calendar. In addition, Your Honor, while I understand that there are other proceedings before this commission in which the parties are engaged, I'm certain that the commission took that into account when it issued this order, which was just in September. So I don't think that the other proceedings should foreshorten the time or change the schedule of this proceeding. The commission has a busy calendar. We recognize that. We think this proceeding has gone on substantially longer than anyone had anticipated. And the sooner that it is closed and can be resolved by the commission, we think that would be the best for all parties, and the parties can turn their attention to whatever other matters they have an interest in. So we'd ask that the schedule be kept as it is. Thank you very much.
Thank you. Okay. Any other parties like to speak to the motion?
Your Honor, if I could make a comment on behalf of OPC, this is Anjali Patel. We support the motion that AOBA has made, especially given the dates and how they fall within the holidays. It would be beneficial to allow sufficient time to brief the 3 proposals that are still on the table. We've asked that company to pick between their 2 MRPs, and they've chosen not to, which means we have to address all 3 proposals, not just 1 MRP and 1 traditional test year. Furthermore, we are concerned with the comment that Pepco's attorney made that they are going to wait to respond to the arguments, or it sounds like that they're going to wait to respond to the arguments that OPC and the interveners have raised at reply brief. We have submitted collectively multiple rounds of testimony. We have aired a lot of concerns, and they should be addressed on opening brief. So that way we do, as the commission said, and crystallize our concerns, our arguments on reply brief, that we're not waiting to see the company's reply brief and how they've addressed our issues. So if the company's planning to wait until reply brief to address our issues, we feel that's patently unfair. And that's why we support the filing of one brief. However, if the commission is still interested in two, we support the extended schedule.
May I be heard, Your Honor?
Yes.
I'm not quite certain what Ms. Patel's argument is with respect to us responding to the post-hearing brief. It's called a reply brief, and everyone anticipates that you reply to the comments or the positions that parties express in their initial brief. That's what we would intend to do, nothing more.
Okay, we thank the parties for the argument. The commission will not rule on this motion at this time. We will hold the motion in abeyance and address it subsequently during the course of the hearing.
Thank you, Your Honor.
And
thank you.
Your Honor.
Thank you, Your Honor.
Pepco has one additional preliminary matter we would like to have addressed before the commission. If I could proceed.
Yes, please.
Okay,
If you could state your name before you speak, please.
Thank you. Kim Hassan. Thank you. And Pepco entered into the joint stipulation with the intention to not only streamline the discovery process, but also to make sure that the commission had before it a complete record. However, there seems to have been some misunderstanding, and the parties did not have a meeting of minds regarding the stipulation of certain documents. In particular, Pepco, it was our understanding rather that the parties agreed to stipulate to all data responses that were referenced in or attached to pre-filed testimony. However, after the joint stipulation was filed and Pepco proffered its list of DRs that were referenced in its testimony to the parties objected and balked, and they stated that they did not mean to agree to stipulate to the DRs sponsored by Pepco witnesses in our testimony. A party's refusal to stipulate to these documents referenced in our testimony is unreasonable, and it's also incomprehensible, being that the parties are asking the commission to read the testimony, but are disallowing the commission to review and rely on the supporting data that's referenced within that testimony. And because it's absurd, it sort of seems that the parties are selectively trying to cherry pick those DRs which are supportive of their positions, while at the same time attempting to restrict the commission's access to those DRs that may support the company's position. And we make the point here, commission, this is not a gotcha case or a civil litigation case where counsel plays games and tries to hide information from opposing parties. Rather, this is an administrative proceeding, and our intention here should be to strive to build a complete record upon which the commission can render a decision. Excluding the referenced DRs does not serve the interest of justice and instead denies the commission access to relevant information. And as a consequence, in order to get this relevant information on the record, the company will be forced to present each and every data response that any witness referenced in their testimony so as to lay a foundation to introduce that into evidence, which will be both an arduous and time-consuming process. Moreover, the company will be required to call to the stand two witnesses that had not previously had questions posed to them to also introduce the data responses that they reference in their testimony. In lieu of this rather inefficient process, and in order to make sure we develop a complete and comprehensive record, Pepco moves that the commission admit into the record any data response that is either attached to or referenced in the party's pre-filed testimony. In addition, and consistent with Rule 134.4, the company also requests that any data response that's admitted into the record be complete in its entirety, as Pepco has noticed that some data responses that were stipulated to by the party and attached as exhibits to their pre-filed testimony were portions or excerpts of the data responses, and again, not the full responses. And again, if our goal here is to build a robust and complete record, I believe it would behoove the commission to ensure that it has the complete data responses before it. Thank you.
OPC in response.
Thank you, Your Honor. Pepco has made two different requests. The first is to admit into the record any data response referenced in their testimony. We made clear to the company, and as is written in the stipulation, as I would note that the company drafted that section, only the data responses, the only thing that we agreed to in the stipulation are data responses that were attached, any exhibits that were attached to the testimony. We did not agree to admit into the record every single data response. When we reviewed the list that Pepco sent us, any data response that was written by our witness, we agreed to allow the company to stipulate into the record. However, we do not agree to allowing the company to put in their own data responses at this point in time. They've had 7 rounds of testimony, 8 rounds potentially. They are a multi-billion-dollar company with very savvy, well-paid attorneys who know how to utilize this process. And it is unfair to the parties to allow the company to now admit data responses that address issues outside of the testimony. That is additional testimony that we have not had an opportunity to review. Therefore, we do not agree to that. We object to that admission. As to the completion of the document, Rule 134.4 discusses a specific document and allowing the other parties an opportunity to introduce into evidence other portions of the original document. Again, we reviewed Pepco's list, which I must say was very extensive, and looked at every single exhibit. Those exhibits where there was an excerpt of the particular document, we have agreed to allow the companies to put in, but they are also seeking to put in hundreds of attachments that have nothing to do with what our party testified in. They've had, again, multiple opportunities to put in any evidence that they wanted. This is not the time to be stuffing into the record additional documents. We've spent millions of dollars in this case reviewing the entire record. OPC has issued 60 sets of discovery. At 61 sets of discovery at this point, we have read every single one, and we put into the record what we believed supported our case. The company had the opportunity to do that. Would note at least 3 of these attachments that they claim are incomplete are work papers from every single witness in the case. There is absolutely zero reason to attach work papers from every single witness to the case when the response we picked dealt with one particular work paper from one particular witness. The other thing that we object to is this is case, as they noted, has been going on for a long time. It is unfortunate that the company is now realizing that they want to put in additional evidence. I am not sure how they are planning to introduce this evidence, as it is from their own witness. They do not get to come up to the stand and proffer additional testimony at this point in time. As the commission has noted, this hearing was intended to be streamlined. The parties were supposed to put in their cases to the extent possible, and we were only supposed to look at those few issues that are disputed and not addressed fully. If the company is thinking that they can use this as an opportunity to now offer additional testimony, we object to that.
If I could respond.
Thank you.
May I respond? May I speak first so Kim can respond to both of us at the same time?
Sure.
Yes.
Okay.
Ms. First, please.
On Friday, we received from Pepco an attempt to put in an additional 98 documents, or at least portions of 98 documents. I want to start off by saying that I wholeheartedly support everything that OPC said. I would make the same exact arguments, plus a couple of more. We received 2 lists. One is they want to supplement the record with attachments or portions of data requests that were not used by the parties in their testimony. Chairman Kane ruled on this exact same issue in formal case 1139 on March 24th in the transcript on page 2015. The motions start a little bit earlier, probably around page 2012. But here, Chairman Kane says, parties do have the right to choose which exhibits they put in and which exhibits to use in their case, so I will not allow it. I will not allow the follow-up. Here's the problem. What Pepco is seeking to do, for just an example, number 1 on their list, they want to put in some missing attachments to A and B of AOBA data request 12-4 to witness Blazunas. Those attachments were only provided in electronic format. They were not formatted for printing. You can't cross-examine on electronic file. The same thing with the second issue on that list. They want to supplement their testimony with a response to staff data request 3-3. It's an electronic file. The next one they want to put in has to do with it's a data request, and it's a 930-page response. And that's to AOBA-C. They say the missing data request and attachments A through L and N through AE. It's totally inappropriate for them to come now with approximately 100 documents the weekend before that were not relevant to the party's case, which is why we didn't use them and why we didn't attach them to our testimony, is totally inappropriate. The problem that we're having is many times the parties ask data requests and we get a response. And sometimes Pepco attaches documents that are just irrelevant. They're work papers, too long. We are not interested in making them part of our case. Sometimes they're confidential documents and we are seeking not to have confidential testimony. And they are irrelevant to our case. For Pepco now, at the last minute, when we don't even have time to go through all the hundreds of pages, if not thousands of attachments that they now want to put into the record, is unconscionable. And we believe that it will deny us due process of going through those attachments. And perhaps we wouldn't have put in the first part of the data response if we knew it was going to be cluttered with thousands of pages that were irrelevant. The next document that Pepco submitted was trying to buttress their case with their own documents. It would not be appropriate for a Pepco witness to take the stand and for Pepco to come and now try to cross-examine that witness on his own data response. That's what's totally inappropriate. It has never been allowed before, and we object to that practice getting started. Thank you.
Thank you, Ms. Francis. I will accompany the final word unless there's another intervener that would like to speak. Hearing none. Any quick response to the company?
Yes, Your Honor. Again, the parties keep making the misstatement that the company is trying to supplement the record, and that is contrary to the truth. We're trying to complete the record. These are not additional DRs that we just found. These are DRs that these parties have propounded and they should have reviewed, and these DRs have been in the docket for months now, such that these parties are very familiar with these documents, so they can't act surprised like this is the first time they have seen them. And I think Ms. Francis really made her point and my point at the same time when she said that the parties specifically put in documents that they felt were relevant to their case. And that's the point we're trying to make here. The parties seem to be trying to cherry pick which DRs they want to present for the commission to consider. And the company's position is that the commission should be provide a comprehensive understanding and presentation of all the relevant DRs, such that the commission should not be required to review a piece of a data request. But if, for example, there are subparts to that data request that may inform the commission's decision making, that information should be available to the commission, such that the commission should not be restricted with regard to the access that it has to information on the record, such that Pepco, again, is not trying to flood the record with irrelevant or unnecessary information. But again, we're trying to make sure that this record is complete, which is why we're requesting that all DRs that are attached and or referenced in testimony be included into the record, as well as the fact that all data responses be complete when they're admitted into the record. Thank you, Your Honor.
Your Honor, one last point. That defeats the purpose of data requests because you never know what Pepco is going to attach to a question. They can attach anything they want, whether it's relevant or not. And my last point is Pepco has attached their discovery to their rebuttal testimony. This is They could have attached all of these to their rebuttal testimony or any other of their other 7 versions of their testimony. They chose not to. This is a last-minute frenetic attempt to supplement the record, and it is unfair to the parties.
If I could respond to that, the parties seem to be under the impression that in order for a DR to be put into the record, you have to attach it to the testimony. And parties fail to point to any rule, practice, or requirement from the commission to that avail. In fact, the company, we were trying to be efficient. So in lieu of cluttering the record with attachments, we chose to insert references, such as one would do in the context of writing a brief. When you write a brief, you insert references and citations. You don't attach the multiple references that you have.
Your Honor, if I may add one small.
Actually, I believe as, please proceed. OPC.
Just one quick point. Pepco seems to be confusing matters. It's not that the parties believe they need to be attached to the document in order to get into the record. They need to be moved into evidence in order to be placed into the record. We attach them to our testimony in order to facilitate the process to allow the company to see what we would like to be moved into the record. The company is here trying to move in its own data responses. These are things that their witnesses wrote. The witnesses could have testified. There is absolutely no reason to attach a data response that comes from their own witness, as they had the opportunity to testify in their testimony. The company got the last word. They filed the last round of testimony. They've had every opportunity to put in evidence that they needed or thought needed to be in the record, including the ones that a number of the items that they feel that they need to supplement the record with now are in response to testimony we filed back in March. So they've had 6-7 months now to look at this and determine what needs to be in the record. We oppose the opportunity that they're trying to use now to put in additional data that we have not had. We've had a chance to review it, but we, not knowing that they wanted it in, we didn't know whether they felt like that was evidence that proved their case. Now they think that if it's evidence that proved their case, they should have done this before. It's too late now. We object.
I have a question for the People's Council. Are you aware, can you cite for the commission any rule that states that this is not allowed?
The rule is that we pre-file testimony, and when we come to the proceeding, the way that the proceedings usually proceed before the commission is that we pre-file testimony, we put into evidence, put into the testimony the evidence we believe the commission should look at. When we get to hearing, that's an opportunity for other parties to cross the company, for the company to cross our parties to test the evidence. What they're trying to do now is add in additional documents, which we will not have an opportunity to test the evidence for. That is why we put in the testimony first and respond to it so we can see what is happening. These are fact-intensive cases. Normally, as you know, in the court, you don't pre-file testimony because you come up, the witness will present their information. But because these are fact-intensive cases, we go through the process of pre-filing in order to show what evidence we're going to rely on. The company has had plenty of opportunity to do so. And as Fran mentioned, this has come up in previous proceedings, and the chairman at the time shut it down and said, no, the company is not allowed to now add new documents into the case. And that is the precedent that we have been working on.
Thank you for responding to my question. I actually want to take an opportunity to review the case and the precedent that was cited by Ms. Francis. So the commission will not rule on this motion at this time. We will also hold it in advance. I will take an opportunity, the commission will take an opportunity to review this, and we will issue our order subsequently.
Thank you, Your Honor.
A question, Your Honor. Being that we do have some testimony for certain witnesses that will not be on the stand, how will we go about introducing, for example, these DRs into the testimony, into the record, rather?
We will address the motion today, so you will have an opportunity before the witness turn is up to address this issue.
Thank you kindly. And one more question for the chairman. Will you be addressing the motions for special appearance?
Yes, that was my next issue. Moving along. Thank you. Are there any objections to the motion for special appearance for Ms. Honorable? Without objection, commission accepts the motion and grants the motion. Are there any other preliminary matters?
Just briefly, I meant to say this with my opening statement. I just want to thank on the record Ms. Brenda Westbrook and Carmen Davis for their enormous amount of help to AOBA in learning how to use this system. And hopefully we'll be using the box appropriately. But I do want to put out a thank you to the Commission Secretary's office. Thank you.
Thank you, Ms. Francis. The commission agrees and supports that. With that,
Your Honor, we have one more small issue, and we agree with AOBA on thanking the Commission Secretary's office. But Pepco has agreed to stipulate into the record Pepco's response to staff data request 2618, and we move to admit that stipulated document into the record at this time.
any response from the company?
No, Your Honor.
All right, it's accepted in the record.
And one more question, since we're going down this avenue. How would the commission like us to, when and how would the commission like us to introduce those stipulated pre-filed testimonies? Because again, some witnesses will not be testifying.
You do it at the end of each witness. We're going to proceed with the two witnesses that are prepared to speak today. And before we move on to another witness, you will have an order from the commission on your motion.
Thank you kindly, Your Chairman.
All right. With that, I believe we are now ready to begin. So,
can I take 5 minutes just to get my witness, because he sort of took a break because he was waiting for the legal discussions to commence and conclude.
I'll take a quick break. Let's just take a quick 10-minute recess. We'll come back at 11:20.
Thank you kindly.
we are back on the record in 1156. And I believe we are now ready for Pepco. Proceed whenever you're ready.
Yes, Your Honor. I believe Company Witness McGowan needs to be sworn in.
Yes, Commission Secretary?
Yes. Mr. McGowan? Sorry, I'm trying to locate him so that I may swear him in.
He's been unmuted.
He's trying to get on camera now.
Okay. Thank you.
I told the commission staff at the break that I do anticipate that we're going to get through this today. I do not anticipate that it will be pretty. And so there will be ups and downs. And so we appreciate everyone's patience as we proceed through this first evidentiary.
And ma'am, on my screen, I don't know if everybody else's, you're showing up as Nicholas Penn. If you could get someone to put your actual correct name on there, it'd be helpful.
We can't hear you. So.
Kim, you're muted.
To do that, I would have to log on and log back off.
Okay, well then you're gonna have to state your name every time because it just throws me off when you speak and it shows Nicholas Penn.
Not a problem, and I'll use a little bass in my voice when I do it.
Well, I get the voice part of it just so it shows up on the record for me. Sorry about that.
No, my apologies. I'm trying to get my witness in front of a camera that's operating. I would blame the electric distribution company, but that's us.
That's not going to help you, Case.
No, small joke.
There's Mr. McGowan.
Good morning, sir. Good morning, sir. Can you please raise your right hand?
I see the witness is trying to talk. Mr. McGowan, I believe there may be.
Okay.
We can hear you.
You can hear me now?
Yes,
right.
We can hear you.
I apologize for the delay.
It's okay.
Good morning, everybody.
Good morning. Commissioner Secretary's office.
Good morning, sir. Can you raise your right hand, please? Do you swear or affirm that the testimony you're about to give in this proceeding is the truth and nothing but the truth, sir?
I do.
Thank you.
Do we have any direct to tender the witness?
Yes, Your Honor. You're right. Good morning, Mr. McGowan. State your name and position.
We can't hear you.
Yeah, I can't hear her at all.
Okay, we're going to get this together.
We hear you now.
All right then. Good morning, Mr. McGowan. Could you please state your name and position for the record, please?
Good morning. My name is Kevin McGowan, McGowan, and I am Vice President of Regulatory Policy and Strategy for Pepco Holdings and Pepco.
Thank you, Mr. McGowan. And do you have before you your pre-filed testimony that you submitted?
Yes, I do.
And specifically, do you have before you your direct testimony, which is labeled Pepco B?
Yes, I do.
And do you have any edits or corrections to that testimony?
I do not.
And if I were to ask you these same questions today, would your answers be the same?
Yes, they would.
And Mr. McGowan, do you adopt this pre-filed testimony as your sworn testimony in this proceeding?
I do.
Okay. Now, if we could move to, do you have before you, Mr. McGowan, your supplemental direct testimony, which has been pre-labeled Pepco 2B?
Yes, I do.
And do you have any edits or corrections to this testimony?
I do have one small correction. On page 11, on table 5, it's around row 9 at the very bottom. There's a row called rate deferral mechanism. And in 2022, in the first column on that row rate deferral mechanism, there is an $18 million number. That should be a negative 18 million. So put two brackets around that. So it would be 18 less 18 would be 0, would be the bottom line. We did correct that in OPC 38-4.
Thank you. And including this correction, Mr. McGowan, if I were to ask you these same questions today, would your answers be the same?
Yes, they would.
And do you adopt this pre-filed testimony as your sworn testimony in this matter?
I do.
Okay. Now, Mr. McGowan, do you also have before you your second supplemental directed testimony, which has been pre-marked 3B?
I do.
And do you have any edits or corrections to this testimony?
I do have one small correction on page 14. On line 14, on page 14, line 22, which is the last line on the page, at the very end, delete the 5 words that will be tracked only. And so the sentence should read, the 5th proposed PIM focuses on, and it continues. And I did correct that in my deposition.
Thank you. And including these corrections that you've just mentioned, if I were to ask you these same questions today, would your answers be the same?
Yes.
And do you adopt this pre-filed testimony as your sworn testimony in this matter?
I do.
Okay. And do you also have before you your rebuttal testimony, which has been pre-marked Pepco 4B?
Yes.
And do you have any edits or corrections to this testimony?
I do not.
And if I were to ask you these same questions today, would your answers be the same?
Yes.
And do you adopt this pre-filed testimony as your sworn testimony in this proceeding?
Yes.
And finally, Mr. McGowan, do you have before you your sir rebuttal testimony, which has been pre-labeled Pepco 5B?
Yes.
And do you have any edits or corrections to this testimony?
I do not.
And if I were to ask you these same questions today, Mr. McGowan, would your answers be the same?
Yes.
And do you adopt these pre-filed testimonies as your sworn testimony in this matter?
Yes.
Okay. Thank you. And Your Honor, the parties have already stipulated to the admission of Mr. McGowan's direct supplemental testimony, second supplemental testimony, direct rebuttal, and sir rebuttal testimonies. And we would ask that these testimonies be marked as such. Specifically, his direct testimony would be marked as Exhibit A or Pepco A. His supplemental direct testimony be marked as Pepco 2. His second supplemental direct testimony be marked as Pepco 3. His rebuttal testimony be marked as Pepco 4. and his surrebuttal testimony will be marked as Pepco 5.
The commission will mark the testimony as Pepco 1 through 5.
Thank you, Your Honor. And the available is now available for cross-examination.
Thank you. People's Counsel?
Yes, Your Honor. Scott Strauss for the Office of People's Counsel. If I may proceed.
Yes, thank you, Mr. Strauss.
Good morning, Mr. McGowan.
Good morning, Mr. Strauss. How are you?
I'm good. How are you, sir?
Well, thanks.
I'm going to focus this morning on your surrebuttal testimony, Exhibit Pepco 5. If you could turn to page 21 of Pepco 5, starting at line 3. Let me know when you're there.
Okay, I'm there.
All right. You described there a set of measures that the company is proposing to implement to offset or mitigate the rate impact of the enhanced multi-year rate plan. Is that correct?
Yes.
And if the enhanced multi-year rate plan is approved, but the proposed offsets that you list here on page 21 are rejected, there would be an immediate increase in customer distribution rates. Is that correct?
I'm sorry, can you repeat the question?
Yes, if the enhanced MRP that you proposed was approved, but the proposed offsets that you have here on page 21 were for some reason rejected, then there'd be an immediate increase in customer distribution rates. Do I have that right?
Yes, that's correct.
By the beginning of 2022, those offsets that you list here on page 21 will no longer fully mitigate the proposed increase in rates under the MRP. Is that correct?
That is correct. The offsets are designed to mitigate the customer impacts through January of 2022 and partially through the year 2022.
Thank you. Thank you. And then actually anticipate my next question. And under the enhanced MRP, the offsets are fully used up as of the beginning of 2023. Is that correct?
That is correct.
All right. If you look at lines 6 through 18 on page 21, the offsets that you described there are a combination of accelerated ratepayer credits, a pause in a regulatory asset amortization, and shareholder contributed funds. Do I have that list correct?
Yes, that's correct.
And if you look specifically at the items you described there on page 21 at lines 9 through 16, what you're describing there are funds that the company already owes to its customers. Isn't that correct?
So lines 9 through 11 are the excess deferred income taxes from the Tax Cuts and Job Act. These are funds that are owed to customers over an extended period of time, which we at this point cannot accelerate under a traditional rate proceeding.
Let me try it again. I think we're getting there. All I'm really asking you is on lines 9 through 18 on page 21, the funds you described there, those are funds that the company already owes to its customers and is proposing to give them back to customers faster than would otherwise be the case. Do I have that right?
So I would say that a little differently. Clearly 9 through 12, as I mentioned, these are funds that are owed customers. These are tax benefits the company has received and is paying those back to customers over a period of time. Lines 13 through 16, which is the Maryland additional subtraction modification. These are tax benefits the company has not received, but will receive over a 30-year period that the company is proposing to accelerate to customers.
All right, those are funds there in lines 13 through 16 that would go back to customers, but you're just proposing to give them back more quickly. Do I have that right?
Yes, that's correct.
Okay, thank you. And under the enhanced MRP, if it's approved as proposed, the revenue requirement used to set distribution rates will increase by a total of $135 million as of January 1, 2023. Do I have that right?
That's correct. The cumulative revenue requirement increase over the multi-year rate plan to recover the company's investments it's made over the past 2 years plus over the 3-year multi-year rate plan would be the 135.9 million.
Thank you. If you could turn to page 16 of your Sir rebuttal, Exhibit 5.
Page 16, okay.
Yeah, and I'm focusing on bullet point number 3, which begins at line 19 and goes over to page 17, line 2.
Okay.
And am I correct that what you show there, sir, is the $135 million increase we just talked about, broken up into what will happen in 2022 and what will be experienced by customers in 2023 under the plan? Do I have that right?
Yes, that's correct.
All right, and then on line 4 there on page 17, you have a bullet point number 4, and you discuss the average annual bill increase for residential customers under the plan, correct?
Yes, that's correct.
All right, Pepco customers pay a bill that includes separate charges for distribution service, for transmission, for certain surcharges, and for the cost of energy supply. Is that correct?
Yes, they pay a bill that has many different charges on it.
And those are the charges, am I correct?
I believe so, yes.
Okay.
I think you covered them all.
Very well. And looking specifically at your text there on page 17, beginning at line 3, the percentages you provide there on lines 4 and line 6, those are percentages that relate to the total bill that the customer pays and not solely the distribution service component. Do I have that right?
Yes, that's correct. And we do that because we believe our customers look at the total bill. When we look at the increase that the company is proposing, we look at in terms of affordability and in terms of the rate increase that we're proposing, we look at the total bill impact.
All right, thank you for that. You're anticipating some of my questions. I appreciate it. It'll move things along. Let me ask you, the energy supply cost component of the bill, percentage-wise and dollar-wise, am I correct that that's the largest part of the bill?
Yes, the supply portion is.
All right, and Mr. McGowan, there could be situations in which one component of the bill could go up, another could go down, such that the overall amount the customer might pay is the same, even though the customer would be paying comparatively more or less for any single component. Do I have that right?
Yes.
And you have a footnote at the bottom of page 17, I believe it's footnote 22, where you indicate that a customer in 2023 will pay a bill that is expected to be 9.9% lower than it was in 2010, correct?
Yes, that's correct. And the purpose of...
Go ahead, sir. I don't mean to...
Right. Sure. So, I mean, the purpose of that footnote is, again, in looking at what the company is proposing in 2011, where the company invested heavily in reliability over that 12-year period through the end of the multi-year rate plan. The overall customer bill is almost 10% lower than it was, 12 years ago. We think that's a very compelling story in terms of the overall customer affordability of these bills.
Right. But again, you're referring there to the total bill, sir, not the distribution service charge, correct?
That is correct. And I would say that the company does have significant influence over the entire bill, including the supply portion.
But the enhanced MRP is focused on the distribution service component. Is that correct?
That's correct, yes.
Thank you. I'd like to show you a document, and I'd like to have it marked as an exhibit. Your Honor, I wish I knew exactly how this works, but I believe it's going to work. We'll put it up there on the screen. I believe we would mark this as OPC Cross Exhibit 1. Let me identify it for the record. It is a copy of the public notice that the company issued in response to DC Code sections 34-901 and 34-909. And this is to give notice to the public of the actually the original MRP, the enhanced MRP, and the traditional rate case and what they will mean for customer rates. Do you see that document, sir?
Yes, I do.
All right. And do you see, as I just stated, that this notice addresses the original MRP, the enhanced MRP, and the traditional rate case?
That is correct.
All right. I want to focus on the part of the notice that deals with the MRP enhanced proposal. That discussion begins on numbered page 8, which is page 5 if you're looking at it in the PDF format. Let me know when you're there, sir.
You said page 5?
It's page 5 of the PDF. It's page 8 down in the lower left. There's a number.
Yes, I'm there.
Okay, very well. And I'm looking at the top of the page, and you see that this is the portion of the notice in which the company explains what's going to happen to the rates if the commission were to fully grant the enhanced proposal. You see that?
Yes, I do.
All right, let's move ahead for a moment to PDF pages 7 and 8, and that would be numbered pages 13 through 15 in the document. Let me know when you're there.
Okay, I'm there.
All right. So on the top of the page numbered 13, you see that the company is going to give monthly impacts on a year-by-year basis, and year 1 is on 13, year 2 on 14, and year 3 on 15. Do you see that?
Yes, I do.
All right, so rate year 1 on page 13, that refers to 2020 as a calendar year. Do I have that right?
Yes, that's correct.
And then rate years 2 and 3 are 2021 and 2022 respectively. Is that correct?
Yes.
All right. Now, we're almost in November. Case hasn't been briefed. At this point, the commission may be unlikely to resolve this case by the end of the year. Do you agree with that?
Yes.
So if the commission were to approve an MRP that begins in 2021, would I be correct that rate year 1 would be 2021, rate year 2, 2023, and rate year 3, 2024? Is that how it would work?
No, the proposal is rate year 1 is 2020, rate year 2 is 2021, and rate year 3 is 2022. The plan would not shift over the years. If the commission issues its decision at the end of this year, then the first rate adjustment would be in rate year 2, which is 2021. But you would not shift the entire multi-year rate plan.
I see. Okay. If we look at pages 13 and 14, which are rate years 1 and 2, the offsets that the company proposes, and this would be for 2020 and 2021, would result, as shown, in 0 increases in the distribution rates during those years, correct?
Yes, that's correct. Now
turn to page 15, where Pepco addresses what happens in rate year 3, and that's 2022. Are you there?
Yes.
And this is the year in which the offsets do not eliminate completely the distribution rate impact. Do I have that right?
Yes.
So if we look under that part of the notice, there's a heading monthly bill change, and it shows, I believe, that a customer there on line 1, a customer taking residential service and purchasing 692 kilowatt hours in a month will see a percentage increase in the distribution charge of 25.9%. Do you see that?
For the distribution portion, but not the total customer bill.
No, that's exactly what I said. For the distribution portion, it will be 25.9%, correct?
That is correct. That's what it says.
All right. That percentage is not mentioned in your rebuttal testimony, correct?
Not in mine, no. Again, as I said, we believe that customers look at total bill, and what I've quoted in my testimony is the percent increase on the customer's total bill.
Is it your position or the company's position that in evaluating the enhanced MRP, the commission should ignore the impact that approval would have on distribution charges imposed on residential customers?
No, I think they would certainly look at it. I think the commission would also look at other factors such as what is the overall impact on the total customer bill. It's important to note that although this proceeding is focused on the distribution charge, there is many things that are included in that distribution component that costs that we incur that help the customers manage their total bill and help the customers to reduce their overall usage. So I think it's important for the commission to look at what the impact is on the overall total customer bill in conjunction with other points they think might be relevant in making their decision.
But again, just to be clear, sir, the total bill isn't what it is at issue in the enhanced multi-year rate plan. It's the distribution service charge, is it not?
For purposes of this proceeding, we are seeking a distribution rate increase, yes.
Thank you. All right, now under the enhanced MRP, on January 1st, 2023, the offsets end in their entirety, correct?
Yes, they do.
And I believe we discussed a few moments ago that at that point, the revenue requirement for distribution service goes up by another $63 million, correct? I believe
Yes,
you say that.
Yes, that's correct. Just wanted to double check.
Thank you. I appreciate that. By what percentage will the distribution charge on the bill change as of January 1st, 2023?
Yeah, unfortunately, I do not have that number with me.
Do you know whether there's any place in the notice where the company tells the public how much the charge will increase once the offset period ends? I didn't see it.
I don't know.
It's not in your rebuttal testimony, correct?
I believe it would be included in company witness Blazunas' testimony and work papers.
All right, we'll have to check that. Do you know why it's not included in the notice, sir?
I do not. I did not prepare the notice.
Well, let me ask you this. Would you think that a residential customer would find that information to be relevant?
That's possible.
Okay. If you could turn back now in the notice to page number 8.
Okay.
And I'm looking at the column there at the top, the residential column. And there's a heading there on that first line at the end, rider ERR. Do you see that?
Yes, I do.
And that's a negative number, correct? It's negative $2.44, correct?
Yes.
And does that amount reflect the amount of the offsets that Pepco will apply to the distribution revenue requirement increase? Is that what that is?
Yeah, this is, I would pose these questions to company witness Blazunas. I know that the rider ERR is the rider that we put in place for year 3, but he would be able to talk to what that number represents.
Fair enough. One final area I wanted to cover with respect to the notice. Again, looking at page 8, down there near the bottom, do you see that there are rates shown for a class called GSLVND?
Yes, I do.
And that's a general service, low voltage, non-demand. Are you familiar with that customer class?
Generally familiar.
Is that a commercial customer class?
It would be, yes.
Okay. Looking at the third and fourth lines under that designation, you see that they're showing the KWH charges for the summer and the winter?
Yes.
As you go across from left to right for rate years 1, 2, and 3, you see that those KWH rates go up each year for those charges?
The rates do change. It's due to the change in the billing determinants that are used to calculate these rates.
So would that be a rate increase each year, or do you see it as something else, sir?
So for year 1 and year 2, it's not a rate increase. If the billing determinants are changing and the company is not increasing rates to collect additional revenue, it's not a rate increase. It's just the rates change over time in order to collect what was previously approved in a prior rate case from the commission.
So the company sells less product but charges more per unit. Is that what you mean? So they collect the same amount of money, but the charge per unit is increased? Is that it?
Well, the way the BSA works is that the commission approves a target revenue per customer based on per class. And depending on, we actually bill customers based on volumetric charges, like a kilowatt hour charge. And to the extent that we bill that customer class more than what the approved BSA target was, because maybe usage was up that month, then we provide customers a credit to bring their bill back down to the target. To the extent the customers use less, then there's a BSA adjustment to allow the company to bill that customer that BSA target. So the rates in the BSA change over time as the billing determinants change and as usage change, but it gets back to the same number, which is what was approved in the prior rate case approved by the commission.
Let me ask you, go back. Thank you for that. I appreciate it. Let me ask you a different question. Go back for a moment. I believe when I asked you if anywhere in the notice it stated what the increase would be in January 1st, as of January 1st, 2023, you said you didn't have that number, but you thought it was in Mr. Blazunis's testimony, correct?
That's correct, yes.
All right. We can certainly ask Mr. Blazunis when he's on the stand that question. If for whatever reason that number is not in his testimony, would the company be willing to provide that information for the record? That is the percentage increase that will occur as of January 1, 2023, if the MRP enhanced is approved as filed.
Yes.
Thank you. And I assume if I asked you, going back to page 8 of the notice and page 9 of the notice, if I asked you under other customer classes about changes in rates over time, you would answer the same, that this had to do with the functioning of the BSA. Do I have that right?
Right. So it's the functioning of the BSA and the changing in the billing determinants over the 3-year period. But again, no rate increase for customers, no incremental revenues for the company in years 1 and year 2 of the enhanced multi-year rate plan.
Well, it's interesting you say it, sir. I understand that there will be no incremental revenue for the company, but the rates will change. The rates are higher that those customers will experience during those years, are they not?
The rates, like as I mentioned, the rates could change as well as the BSA adjustment over that time based on the billing determinants and based on the customer usage. But again, the rates are adjusting such that we are collecting the rate increase that was approved by the commission in the prior rate case.
So would you consider that a bill increase for these customers?
I would not. And the reason why is in the last rate case, the parties reviewed the company's application and the commission approved a rate increase, and the customer bill impact at that time was evaluated and ultimately approved by the commission. Over time, as the billing determinants change and as usage change and the BSA amount changes, those changes aren't rate increases. They're just adjustments to collect the revenues that the commission previously approved. If you were to include those BSA adjustments in this analysis, you would be double counting the rate increase. You would have incorporated the rate increase from the last rate case, and then you would also be including it in another rate increase. And so it's not appropriate to look at the BSA adjustments to the billing determinants in the current rate case as a rate increase, because they're doing nothing more than collecting the rate increase that was approved by the commission in the last rate case.
Now let's turn back to your testimony at page 21. That's Exhibit 5.
Okay, I'm there.
Great. If the revenue requirement adopted by the commission in this proceeding turns out to be less than the amount proposed by the company, would the amount of the customer offsets correspondingly be less as well?
So the purpose of these offsets were to offset the revenue requirement that the company was proposing, such that there would be no distribution rate increase until January 1, 2022. So these offsets were designed to reduce the top line revenue requirement the commission was asking for. To the extent that that revenue requirement was reduced, then these offsets would also be reduced by an equal amount, such that we would accomplish the same objective of no distribution rate increase until January 1, 2022, and then a partial increase in the year of 2022.
Very well, then. That is actually, you've anticipated my question again, sir. In other words, there's a dollar for dollar relationship between the amount of the revenue requirement and the offset. Is that correct?
I'm not sure I'd frame it up as a dollar for dollar. I'm just saying that these offsets were intended to eliminate any distribution increase over the first 2 years of the plan, and then partially in the third year. And to the extent that those top line revenues are adjusted, there would be a corresponding offset with these amortizations.
Right.
And if it's a dollar for dollar, possibly, but that's how it was designed.
Okay, fair enough. I don't mean to argue with you. Thank you. Let me ask you this. If the revenue requirement is less than what the company has proposed and the offsets are reduced, does the company have an order of operations here as to which of the offsets would be removed first? Let's say that the revenue requirement adopted was sufficiently below what the company had asked for, that a whole category of these offsets were unnecessary to offset the rate increase. Is there an order in which the company would remove those?
I'm not aware of one. I would. Company witness Wolverton is the sponsor of the revenue requirement. I would pose that question to him.
Very well. Turn to page 19 of your testimony. That's Exhibit 5.
Okay.
At line 7 to 10, you state that the company recognizes it'll take more than a few months for the district to begin to recover from the adverse impacts of the pandemic, correct?
Yes.
And you go on to say that the company shares the concerns of others that the customers may continue to face challenges after the pandemic, correct?
Yes.
And you submitted this testimony back in June. I assume that's still your opinion today?
Yes.
And as we sit here today in our various remote locations, sir, the company does not know when the current public health emergency will abate. Is that correct?
No one knows.
Fair enough. Would you turn to page 33 of your Sir Rebuttal, Exhibit 5?
Okay, I'm there.
Looking at lines 4 through 7, you state that the company commits not to file a petition to increase distribution rates that would become effective prior to January 1st, 2023. Do you see that?
Yes.
Now, as I read this, then under the enhanced MRP, the company could make a filing to increase distribution rates during 2022, for example, with the intention that the new rates not go into effect until the beginning of 2023. Is that correct? Am I reading that right?
I would agree with that comment. In a multi-year rate plan, a 3-year multi-year rate plan, there would be a filing every 3 years. And then the multi-year rate plan would cover the 3-year period in the plan. Since this multi-year rate plan was filed in May of 2019, 3 years after that, you would expect another multi-year rate plan to be filed, and then every 3 years after that point.
So then would it be correct then that Pepco anticipates filing another, assuming this proposal is approved, Pepco anticipates filing another rate case in 2022?
That decision has not been made yet. A lot of it depends on the outcome of this case. But it's likely that we could file a rate case in 2022.
Give me a moment. I believe I've got 1 minute left on my 40 minutes, sir. I have nothing further, Mr. McGowan. Thank you for your time.
Great. Thank you.
Chairman, you're muted.
Thank you for the company. Thank you for OPC.
Your Honor, do I need to move the admission of my exhibit at this point, or should I wait till the end of the cross?
They are already, no, it's quite all right. The commission accepts.
Very well.
Foundation's already been laid. They've already been authenticated. Commission accepts your exhibits without objection. We have Aoba, your witness.
Yes, Your Honor. Good afternoon, Mr. McGowan. Before I begin my brief cross, Mr. Strauss asked you to provide certain numbers for the residential class in regard to the public notice. Would you be willing to provide that analysis for the commercial classes, all of them?
Yes, he asked us to provide the customer bill impact at the beginning of rate year, essentially rate year 4, once the offsets expire, and we would provide that. I believe that they are in subject to check in Mr. Blazunas' work papers, but if not, we will provide those.
Did Mr. Strauss, I might not have heard it correctly, did Mr. Strauss ask you to provide that without those BSA offsets?
He was not that specific.
I would like to see the numbers that way without the BSA offsets, if you would be willing to provide that, if it's not already in Mr. Blazunas' testimony.
Let me get back to you on that, Ms. Francis. Not trying to be elusive. I just want to make sure I understand what that means. If I can just confer with the rates team, and I'll let you know.
Thank you. Your Honor, now it might be a little challenging. I would like to introduce an exhibit. I have Kevin Carey on the line, who's going to try to put up AOBA's list of cross-examination exhibits, if he could somehow do that. I think all parties have that. There is only one exhibit on that list. I don't know if the commission secretary's office is able to do that. It was filed on 24th. It is one exhibit. Could I ask that they?
We'll need a moment.
Okay, thank you.
Thank you, Carmen.
Okay, thank you very much. Could you please put on, after the letter, the next page? Go one page after that. Thank you. Mr. McGowan, are you familiar with this document, which was filed in the PEPSAR and formal case number 1139? It is the BSA analysis that the company filed on October 12th. I believe you are the signature on the document. Please show page 2, the next page.
Yes, I am. I am familiar with it.
Can you verify the accuracy of this document? There's the attachment is with it, all of the numbers.
The document was accurate when filed, and there's nothing that I'm aware of that has changed that.
Your Honor, I would like to have this document, which I have called DCPSC docket PEPSAR and formal case number 1139 Pepco BSA report filed October 12th, 2020, identified as AOBA Exhibit 1.
So, Mark.
Mr. McGowan, I'm going to ask you to please turn to page 4 of 7 of this document. Keep going. That's the page.
Okay. I'm glad I have a hard copy.
I'm sorry?
I said I'm glad I have a hard copy. It's kind of
Yeah.
hard to see, but yes, I'm there.
Okay, me too. I just have one question. Would you accept, subject to check, that the GTLD class was under recovered for the month of September by 35.7%?
Can I ask you how you came up with that number?
Yes, I took a look at, let's see, I multiplied the 309, and I'm looking at the GTLD class, the 309 number of customers times the next line, which was the revenue per customer. And I checked that, and that's how you got the $7.6 million. Then I took going down a few lines, looked at line, I guess it's C1, and I looked at the $2.7 million number, and I took 2.7, I divided that by the 7.6 million, and I got 35.7%. And I believe that's what the company is suggesting, that it under collected for that month. Would you accept that?
I believe the way this works, and maybe we're just describing it a little bit differently, is that we're authorized to bill a certain amount, and we in terms of the actual usage and demand of customers in that month, it was 37% subject to check, but that's before the BSA adjustment that's allowed to bill those customers in the following month.
I understand that. But
Okay.
but this was is showing is that you suggested on this chart that you were allowed to collect I'm rounding, $7.6 million, and you only collected $4.88 million. Is that correct?
Not exactly. The 7.6 million is what is authorized for the company to collect from the prior rate case. So I think we're in agreement on that line.
Correct.
The 4.8 million is what was billed customers from our billing system. So that's the usage and the demand. So that's the actual amount that they were billed. And so the delta is what would normally be recovered through the BSA because of usage and demand was lower than what is authorized in the last rate case.
Okay, and that was the 2.7 million, correct?
Yes. So that it's a difference between what were the target BSA number and the amount that we actually billed from our billing system based on usage and demand.
Okay, and you do agree that that was an under collection by approximately 35.7%.
Not sure I agree with the word under collection. It's just that the amount that customers were billed in the month of September based on usage and demand was 37% less than what the BSA target was.
Okay. Thank you, Mr. McGowan. I have no more questions, Your Honor. At the appropriate time, I will move the admission of this exhibit.
Thank you, Ms. Francis. District Government. District Government, do you have any questions?
Yes, sorry. Thank you, Your Honor.
Don't mean to rush. Take your time.
Trying to get myself off mute. Good afternoon, Mr. McCowan. How are you?
Good, Mr. Caldwell. How are you? Good seeing you again.
Good to see you. You have in front of you the District of Columbia's list of cross-examination exhibits.
I do, yes.
Great.
Give me 1 second.
Okay, I'm going to try to pull them up here and share them.
Okay, whenever you're ready.
Whiteboard. I apologize. I've never done this before, so I'm not really sure how to do this. Can you see anything on the screen other than video?
So I can see the very bottom of the, what looks to be DCG-24. So it is displaying, but it's just like the bottom right-hand corner.
I got you. Okay, great. Let's see here. Can you please turn to what was preliminarily identified as DCG Exhibit 1?
All right, let me make sure I know which one that is. All right, so data request 1-2.
That is correct.
Okay.
That is the company's response to the District of Columbia government's data request 1-2 that you are the sponsor of, correct?
That is correct.
And are we, I'm sorry, maybe this is a question for council for Pepco, but have we stipulated that we are going to forego running through the foundational questions as to these data requests, or do I need to ask the witness whether or not
I'm asking for what is the rate increase for all?
Ms. Francis, we can hear you. We ask you to mute your microphone.
did we stipulate to the foundational foundation of these exhibits? Right?
Ms. Caldwell, that is my understanding. Pepco, do you have an objection?
No, Your Honor, we don't have an objection. Again, our intent here is trying to create a robust and comprehensive record.
Please proceed. You no need
Okay,
to.
so I'm just going to go right into the exhibits. Now, specifically, oops. Bear with me 1 second. I apologize. The question asks, in reference to your statement in your direct testimony that the company identified relevant areas of utility performance that it determined were important to the District of Columbia and its customers. So Part B asks for the identification and provide all analysis and documents used to identify areas of utility performance that are important to the District of Columbia and its customers. And in your response, you say that the electric quality of service standards that were adopted by the commission are important to the district and its customers, as well as the clean energy bill passed in 2018, and 4 MRP working group sessions, comments received in response to those. So those are the documents that you refer to as being sort of enshrining the concerns regarding utility performance for the District of Columbia and its customers. Is that correct?
Yes, I mean those were the key documents that informed our discussion on the PIMs that we would propose in our filing. I mean the 4 working groups. Obviously, there was a discussion with many parties on PIMs that we would like to include, but didn't believe it was the right time for it. But these were the key items. We obviously we're engaged in the district every day. We talk to many people daily, and we know what's important to the district. And so that helps inform our decision as well. But these were in terms of the analysis or documents. These are the key documents that we believe were relevant to answer the question.
Correct. And so I noticed that you did not list the sustainable DC plan. Is that correct?
That's not on this list. That's correct.
All right, and you also didn't list the clean energy DC plan, correct?
I'm sorry?
You also did not list the clean energy DC plan, correct?
That's correct. That's not on this list.
Okay.
But it's, I guess, as a response, there was a lot of things that we look at in the district. The fact that I did not list it on this does not mean that we ignored it. There are, as you know, many working groups in the district. There's many initiatives underway around clean energy, carbon reduction. All of those help inform our decisions on what's important and what we believe the district is most important in pursuing.
Okay, but you didn't identify it as being as an important document on this list.
Not on this data request. That's true.
Okay. Can I then now turn your attention to, I'm sorry, can I have the, I guess, was preliminarily marked as DCG1 marked as DCG1?
So marked.
Let's see, can I now turn your attention to what was preliminarily marked DCG-2?
Right, so that's DR1-5.
Correct.
Okay.
I highlighted some information on here. I'm going to read the highlighted portion of your response to 1-5B. In response to the question of, explain how the proposed MRP provides a superior approach to incentivizing high levels of service at a reasonable cost relative to the current structure. The highlighted portion of your response says the MRP provides a framework that allows the Commission, customers, and other stakeholders to engage in a review and discussion of the company's investment plans, expected levels of performance, and cost to achieve the desired level of performance as discussed in my direct testimony on page 22. You see that?
I do, yes.
Okay. The review and the discussion of the company's investment plans that's contemplated in the MRP, it doesn't contemplate that the Commission determined that specific investments are prudent in advance of approving the MRP. Is that correct?
The company always has the burden of proof to demonstrate that a investment is prudent, whether it's part of this proceeding or whether it's part of the annual reconciliation filing or annual information filing, depending on which MRP is chosen. But the company always has the burden of proof to demonstrate prudency, whether before or during.
Okay, but if the investments have yet to be made, and the Commission is considering whether or not to approve the MRP, how can there be a discussion about whether or not the investments are prudent?
So as part of the company's application, we provided a tremendous amount of information on the capital projects that the company is proposing to construct over the 3-year multi-year rate plan. We've received obviously lots of discovery on that, and parties can comment on whether those investments that the company is making either fits into where the city, the direction of the city, the goals of the district. But it's an opportunity for parties to review what we are doing and what performance we are delivering. So parties have the ability to comment on whether those investments are appropriate or not. And then it would be up to the decision of the Commission to decide whether the 3-year capital plan as proposed is appropriate or if modifications should be made. And that's
okay.
all done before the work is even completed or started.
Okay. Okay. And we're in that process right now as we're sort of contemplating whether or not to approve, or the Commission is contemplating whether or not to approve this MRP. Has there been any specific investments that, as a result of discussions that the parties have had, that the company has decided to remove from the MRP because, as a result, perhaps the company has decided that it's not prudent?
So as you know, in the enhanced MRP, the company has proposed to reduce the capital expenditures in 21 and 22 by 10% or $60 million. But in terms of actual projects that parties have filed testimony on, requesting that the company remove those or opposing them, I would ask company witness Clark. He's the one that sponsors the capital plan.
Okay, so really, you're talking more of revenue levels and not specific projects, correct?
I'm sorry, on this data request?
Yeah, this statement is meant to refer more to overall levels of revenue as opposed to specific projects. Is that correct?
Not at all. What this data request is responding to is that the many benefits that a multi-year rate plan can provide customers and stakeholders is it allows the stakeholders to review the company's construction plan and its operating and maintenance plan over the next 3 years. It has an opportunity to evaluate and understand what level of performance the company is looking to drive over that 3-year period, and also allows the parties to understand what the cost is and what the customer bill impact is. So that 3-year process it's an opportunity to engage parties to better understand what the company is doing. And we think that's just a much superior method, much more collaborative method than what we do today, which is filing a rate case for investments that were made in a prior period.
Okay. So just so I'm clear, then, the reduction in revenue that was proposed by the company as part of the enhanced multi-year rate plan was just an overall level of revenue and did not encompass specific projects that the company is no longer going to invest in over this MRP term as a result of comments and discussion that was had by parties while reviewing this MRP. Is that correct?
I would not agree with that statement. Clearly, parties raised general comments about the level of spend that the company had proposed in its multi-year rate plan given the COVID-19 situation. So in response to that, the company proposed to reduce capital spending by $60 million or 10% over the 21-22 period. We didn't just reduce the revenue requirement. We reduced the level of capital spend the company plans to make. We reduced other things, but the resulting impact of that, including the offsets that we talked about previously when I was talking with OPC, all that resulted in the reduction of revenue requirement.
Right. Okay. But we don't know which specific projects are not going to be invested in now as a result of that revenue reduction.
So what the company has proposed is that if the commission approves the enhanced MRP and approves the reduction of 60 million, the company will file within 90 or 120 days after the order, will file the detailed capital plan that will list and identify which of those projects equal $60 million that was removed from the capital plan.
Okay. Thank you. So, I'm sorry, can I have what was preliminarily marked as DCG-2, marked for identification as DCG-2?
So mark.
Thank you. Moving your attention to what was preliminarily marked DCG-3.
All right, that's DR response 1-6. Okay, I'm there.
Correct. This question asked whether there were no industries. In reference to your testimony that says, where you state, as there is no industry standard approach to setting PIM financial risks and rewards, the company proposed financial risks and rewards that were meaningful and balanced. And part A of this question asked you to define meaningful and balanced as used in the above quote testimony. Now, you state in your response that there were no studies, no analysis for the specific risk and reward structure. If that is true, how can the company say that the risk and reward structure is meaningful without studies or analysis?
So when let me make sure I got the right reference to this. 42. So as the company developed the financial incentives and penalties for these PIMs, as we noted here, there was not there's no industry standard on this. We did work with Brattle to search and do some research on the market as to kind of what was out there and what PIMs were available. We provided some of that information in DRs, but there really is no standard. And so it is I will say it is a subjective based on our understanding of PIMs that are used today. And we wanted to propose something that we thought was meaningful and balanced, and meaningful in that there is an incentive and it's meaningful to drive performance. And also that if we didn't meet the goal, that it would be meaningful in terms of the penalty. So we believe that what we've set here as a target is meaningful. And in terms of being balanced, there should be an equal opportunity for the company to achieve a reward as it is that it would fall short of it. So that's how we develop the PIMs in our proposal.
Bear with me one more moment. All right. I'd like to, well, can I have what was preliminarily marked as DCG-3 marked for identification as DCG3?
So more.
And then, Mr. McGowan, turning your attention to what's been preliminarily marked as DCG-6.
Right, so that's data request 125.
Yeah.
1-25, excuse me.
1-25. This question refers you to Commission's Order 18846 from formal case 1139, where the Commission reiterated its understanding that alternative rate-making mechanisms could deliver service improvements, management innovation, and more operational efficiencies and less frequent rate cases. And the question then goes on to ask you to identify and provide any estimates Pepco has performed to measure the magnitude of any operational efficiencies that it expects to achieve under the MRP, and explain how those estimates were developed. And in your response in C, you state that the requested analysis has not been performed. If there's been no analysis measure or to determine the magnitude of any operational efficiencies, what is the basis for this statement?
So this DR, I believe, is referring to the original MRP. And the way that, that we did not conduct a study or to estimate or calculate what the operational efficiencies or what the magnitude of it could be. What we've proposed is a structure such that there's incentives for the company to provide operational efficiencies and lower cost, in the sense that it has the opportunity to share in some of that upside with customers. It's also a mechanism that provides, if in fact we don't meet our targets, that the company will not recover those costs up to the deadband of the ROE range, and then and again, that's also, and then below that amount, there's an opportunity to request recovery, but there's no guarantee. And so it's in the structure that we proposed in the earnings sharing mechanism that we believe provides those operational efficiencies and opportunities to save money, because it does provide an incentive to the company. But as we said, we did not conduct a study as to what the dollar amounts would be. We proposed the structure based on our understanding of how this would work.
Thank you. And can I have what was preliminarily marked as DCG 6 marked for identification as DCG 4?
So marked.
Thank you. Mr. McGowan, going back up to what was preliminarily marked as DCG-4, which is the company's response to DCG data request 1-7. This question asks, in reference to the district's Clean Energy Act's energy efficiency, demand response, and transportation electrification goals. Your testimony states that until these programs are implemented in the District of Columbia, the company cannot develop these related PIMs, and thus the company decided it was premature to propose PIMs in this filing. The question asks why the company cannot develop PIMs in advance of programs being designed to implement the district's clean energy goals. And your response essentially states that many of these goals are being worked through as part of the Power Path DC working groups, and that while these goals are under development, that the company doesn't feel that it's appropriate to incorporate any measures within its MRP to address these issues at this time. Is that sort of a correct sort of statement of what your response says?
I mean, my response is what it says on the data request.
Okay. You say that the company did not want to complicate the efforts of the Power Path DC proceeding or this rate proceeding by introducing issues under development in Power Path DC into this rate case proceeding, correct?
That's correct, yes.
Okay. If the company believes that it must wait until issues under consideration in the Power Path DC are decided before it can propose measures to incentivize energy efficiency or demand response or transportation electrification, then why shouldn't the design of the MRP similarly be subjected to the Power Path DC stakeholder process, as suggested by Commissioner Beverly in his October 21st, 2020 statement?
Can you repeat that question?
I said, if the company believes that it must wait until issues that are under consideration in Power Path DC are decided before it can propose any sort of measures to incentivize energy efficiency, demand response, transportation electrification, why shouldn't the design of the MRP, which is supposed to be advancing the goals of the district as far as clean energy, why shouldn't that be subjected to the Power Path DC stakeholder process as well?
So we see those as two complete different issues. The response to this DR, and also you participated in the working group sessions that we held, you and your team, we discussed probably a dozen different PIMs that the company actually was proposing to consider. But it was clear from those discussions, and it was also clear in the PIM working group that was set up by the commission during the actual proceeding, that a PIM has to be set up such that the company can obtain it, has to be specific, and trying to put a goal out in front or a PIM, if the company develops a PIM that tries to achieve a goal that hasn't been clearly defined, or we don't know what our role is, I would question what the purpose of the PIM is really designed to do. And I'll give you a great example. We could have easily.
Mr. McGowan, I'm not talking about PIMs. I'm talking about the MRP itself. If one of the goals of the MRP is to, would you agree that one of the goals of the MRP is to advance the district's clean energy policies?
Yes.
Okay. So if that's one of the goals of the MRP, and I assume you would agree that measures to promote energy efficiency and to promote transportation electrification, those types of things that are the subject of these PIMs, but these are topics in general that are meant to promote the district's clean energy policies. Is that true?
Yes.
Okay. So if one of the goals of the MRP is to advance the district's clean energy policies, why shouldn't, similar to the transportation electrification and the other energy efficiency matters discussed as part of Power Path DC, why shouldn't the MRP also be subject to consideration under the Power Path DC?
Right. So again, we see those as two complete separate issues. Some of the working groups and the initiatives under the Power Path DC is a subset of what needs to be done to achieve the clean energy goals of the district. I mean, today customers are asking for DER. They're asking for electric vehicles. They're asking for battery storage. All this requires infrastructure that the company needs to invest to be able to support. There's a lot of interconnection requests that the company receives to upgrade systems to allow interconnection of solar. And so, also greenhouse gas reductions, a lot of things that the company can be doing that goes beyond the obligation to provide safe and reliable service. A lot of those things that we can do today that we don't have to wait for Power Path DC to do the multi-year rate plan. I think the point of this DR and my whole point is that there are initiatives and decisions that will come out of the Power Path DC that can certainly support the MRP effort, but there's a lot of things that are going on today that can continue without the Power Path DC.
All right. Can I have what was preliminarily marked as DCG -4 marked for identification as DCG5?
So mark.
Thank you. Mr. McGowan, can you I'll scroll down to what's been preliminarily marked as DCG15?
All right. So DR 6-2.
Correct.
Okay, I'm there.
All right. So question, refers to your testimony, page 22, lines 12 through 16, where you state that Pepco is, quote, seeking to optimize the grid and to make new and innovative opportunities available to customers, and that the proposed MRP and PIMs provide the transparency necessary and opportunity to advance these innovative investments. And then the question asks you, what, specifically subpart C, it asks, what specific planned investments contained in the current MRP proposal does Pepco consider will enhance grid modernization? You see that?
Yes.
And in your response to C, you say a reliable and resilient grid is the foundation for grid modernization. Accordingly, the projects contained in the construction report provide the foundation to enable grid modernization. Is it Pepco's position that investments that enhance reliability also enhance grid modernization?
Yes, and I believe your consultant would agree with that.
But isn't Pepco already obligated to provide reliable service to customers?
So we have an obligation to meet the minimum standards under EQSS.
Are there additional investments that Pepco proposes in its MRP to enhance reliability for grid modernization that it wouldn't propose to enhance reliability in general?
Well, as we have been very clear, if an MRP is not approved, then we would have, if recovery of costs would stay under a traditional historic test year approach, we would be limited in terms of the amount and the timing that we could invest in reliability in some of these grid modernization projects. We'd be capital constrained. We'd have to prioritize which ones are most important and which ones we could defer. But we would do that in the context of meeting all the EQSS standards and also anything that the commission mandated the company to do.
Okay, but you can't identify any specific projects that enhance grid modernization that don't, or sorry, strike that. You can't identify any specific projects that are proposed in this MRP that enhance grid modernization that wouldn't be proposed if you didn't have this MRP. Is that correct?
So I know that, Mr. Clark sponsored, I believe, our response to DCG DR 511, which does provide some examples. But we have noted in our prior DRs that the company has not gone through an extensive evaluation of which projects it would or would not do under an MRP or under a traditional test year approach. We've been, I think, upfront that if we have to recover costs under a traditional test year approach going forward, we would have to prioritize capital and we would be constrained on being able to invest at the pace that the parties may want us to help achieve some of these goals. Any investment that goes beyond our obligation to provide safe and reliable service, to meet the EQSS standards, or any other mandates from the commission, any investment that would go beyond those would be subject to review and prioritization.
All right. Well, subpart D to this question also asks what specific planned investments contained in the current MRP proposal does Pepco consider will facilitate greenhouse gas emissions reductions? Are there any specific investments in this MRP to reduce greenhouse gas emissions reductions that Pepco is proposing that wouldn't also further reliable service and wouldn't be part of this MRP?
Yeah, I don't recall which investments in the capital plan would address that. I would address that question to company witness Clark. I would say that the company does have many initiatives underway that we are pursuing that will reduce greenhouse gas emissions. I do know for a fact.
I see you highlighted 3 bulleted points. The EV and solar hosting capacity map, ongoing LED light conversion, employee workplace charging. But those are things you say that are already they're currently underway right now, right?
That's correct, yes.
You don't have an MRP right now. So these are perhaps initiatives that are also contained in the MRP, but they're continuations of initiatives that are ongoing without an MRP, correct?
That is correct, yes.
Thank you. Can I have what was preliminarily marked as DCG-15, marked for identification as DCG-6?
So mark.
Let's see, one more exhibit. Can I now bring your attention to what was preliminarily marked as DCG-10?
So Mark.
Data request 140.
And this question asks, in Pepco's proposed annual reconciliation filings, it asks to explain in detail what components of the annual reconciliation filing are designed to comply with order number 1846. That's the order that we previously discussed from formal case 1139 that Pepco uses as its basis for proposing this MRP. Isn't that correct? Do you recall that discussion? And that order states that Pepco needs to provide a mechanism that allows parties to reconcile any forecasted components to subsequent actuals for the same test year. Is that accurate?
Yes.
What level of detail does Pepco plan to contain in its cost variance reports? Is it going to be based on individual project level variances, or will it be on a distribution wide sort of variance basis?
So company witness Wolverton provides in his, I believe, his rebuttal testimony, a detail of what information will be provided. And it would be by project at the project level, both the forecasted amount versus actual. And to the extent that the variances on those projects exceed certain thresholds, in our filing, we'll provide variance analysis and information on why there's a variance. But he covers that in great detail in his testimony.
Okay, I'll refer those questions to him. I have no further questions. Thank you.
Okay, thank you.
We thank the district government. I have one more party on my list that wanted to question witness Leona. Do we have them?
Yes, Your Honor. I'm ready.
Please, your witness.
Thank you, Commissioner. Good afternoon, Mr. John.
Good afternoon.
My name is Brian Petruska. I am a counsel to the Baltimore Washington Laborers. In case you didn't know, my client is a labor union that represents.
Sir, on my end, you're cutting out.
You can't hear me?
I can hear you, but you're cutting really bad. So I don't know if you need to slow down or get closer to your mic.
All right. If you continue to have the problem, just feel free to interrupt me. All right. My client, Baltimore Washington Laborers District Council, we represent construction workers, many of whom work on Pepco's construction lines, but working for outside contractors, not directly employed by Pepco. And I'm going to ask questions today about PIMS, Performance Incentive Mechanism. Are you hearing me?
Yes, I believe I caught most of that. So I think we're good.
Okay. I think it's going to be important for me to remain close to the mic. Okay.
Please do. And slow down just a bit.
Sure thing. All right. So you do understand that Pepco hires numerous construction contractors to perform construction services on Pepco's electric lines, right?
Yes.
Okay. And those employees aren't Pepco employees. They're employed by the contractors, right?
Yes.
Okay. That's going to be the group that I'm going to be talking about here, just to be clear in advance. Okay.
Okay.
Okay. And you understand that when Pepco engages the services of these companies, they have the contractors enter into an agreement, and that Pepco has a sort of master form of agreement that it uses for these contractors.
That is my understanding.
My understanding too. Nice. All right. So I'm going to try to just have a discussion with you about PIMs that my client BWLDC is proposing in this case to try to address issues that in those contracted out construction workers. And so for the purpose of these questions, the first one that we're going to be discussing is a performance incentive that proposes a reduction. It's a penalty, a reduction on Pepco's return of equity if the commission finds that Pepco fails to resolve, to investigate or resolve a credible allegation that any of Pepco's contractors are not complying with DC's minimum wage. And for purposes of this, for our discussions, I'm going to throw out an amount of $100,000 as a penalty. Okay, is that straightforward enough as an incentive?
So just to be clear, are you referring to filed testimony, or is this a hypothetical example that you're introducing?
This is a PIM that BWLDC is proposing in this case.
Can you reference me to where in the filing it's being proposed?
Well, so we haven't filed it yet. We intend to file it on or before November 2nd.
You cut out again. You plan to file it when?
On or before November 2nd.
Objection, Your Honor. I object, being that first, the commission has directed parties to file any proposed PIMs prior to the date of the hearing, such that it is very unfair to now to try to pose questions to my witness, and he's not had a chance to review these proposals that BWLDC claims that they will be proffering next month.
Response?
My response is that pursuant to commission order, and I can get the number, but pursuant to the commission's prior order, the commission set a deadline of November 2nd for parties to file proposed PIMs.
Understood, but at this point, the commission, it's unfair to ask my witness to respond to hypothetical questions. Again, there's no preparation. There was nothing put before him. There is no foundation being laid with regard to the proposal that BWLDC plans to put forth before the commission. Such that right now they're just asking blank questions, throwing it at my client, which seems to be very unfair.
You know, I'm going to allow the question to proceed. The witness can answer to the best of his ability.
Thank you, Your Honor. Okay.
Can I ask you to repeat your example?
Certainly. The proposal is a reduction on Pepco's return of equity by $100,000 if the commission finds that Pepco has failed to investigate or resolve credible allegations that any of Pepco's contractors are not complying with the DC minimum wage. And I'm just want to make sure that that makes sense to you as a proposed PIM. Not asking if you agree with it, just that you understand it.
Well, I guess first of all, these are not our employees, and I think you're asking for us to investigate a company allegations by an employee for that are not employees of the company. If there's any wage disputes, there are agencies in the federal government and also in the district that are capable and equipped to investigate those claims. I think requiring the company to investigate a wage dispute with a contractor is something that would not be appropriate.
Okay, that's a fair point. That's a fair point. In response to that, I would like to show you an exhibit, and so I'm going to try this sharing the screen. Here. All right. Okay. All right. My computer's telling me you should be able to see this.
Yes.
It is a letter dated October 23rd, 2017 from Pepco Peter E. Meyer. You see that?
I do, yes.
And, oh, here, let me, and you'll see that this letter has been included in the record of this proceeding several times, but it was included as a response to your a response that you sponsored to BWLDC's first data request. Do you see that on the screen?
Yes, I do.
So here's the attachment. So I'm going to show you, this is page 2 and 3 of this letter. And page 2 at the bottom of it, which should be at the top of your screen, Pepco states that it has adopted Exelon's master terms and conditions for the purchase of products and services, Exelon TNCs, in the contracts with its third-party contractors. Exelon TNCs expressly require that the contractor and any subcontractor, quote, strictly adhere and continue throughout the term of these terms and conditions to strictly adhere to all applicable laws in the jurisdictions, and it goes on. But in sum, it requires its contractors to follow the law. Is that fair?
Yes, it does.
Okay. And then if you go down to the last paragraph of that section I was just reading from, the letter says, Exelon TNCs give Pepco substantial tools to enforce contractors' compliance with these obligations. Do you see that?
I do, yes.
And it's talking about there when it says tools to enforce compliance, it's referring to compliance, the obligation that they comply with labor and employment laws. That's in the prior paragraph. Do you see that?
I believe what they're referring to is a compliance with the company's TNCs, which require them to comply with all federal and state laws in city.
Right. And in specifying the tools that are available to Pepco, one is that they require the contractor to promptly, upon Pepco's request, to furnish such documentation as may be required by Pepco to evidence compliance with the obligation set forth above. Do you see that?
I've lost you where you are are you on the, which paragraph are you on?
Sorry, that is the, it'd be the third paragraph on page 3. Second sentence, I read the second sentence.
Yes, I do see that.
And then the last sentence says that the TNCs give Pepco the right to audit a contractor's files and records. And the last portion is including wage and hour records. Do you see that?
I do, yes.
Okay, so what this letter is saying is Pepco has tools to address the issue of non-compliance by its contractors with the minimum wage, the DC minimum wage. Is that fair?
I think evidence to comply with the terms and conditions of the contract, which I assume would mean that meeting the federal and city laws on minimum wage.
Right. In the testimony of BWLDC witness Steve Lannon, it was in his SIR rebuttal, he presented a survey performed by BWLDC that found that in 2019, 22% of the contracted out workers were found to be earning less than the minimum wage. Are you aware of that portion of his testimony?
I did not read his testimony in great detail.
Okay.
I believe company witness Sullivan, who manages these contracts, would be familiar with that.
Yes, and the testimony was in response to his testimony, so I appreciate that.
Okay.
Do you agree that Pepco did not offer any evidence disputing this finding from the survey?
I would direct that question to company witness Sullivan.
Thank you. And the survey further found that in 2018, 21% of Pepco contracted out workers were not paid the minimum wage. Were you aware of that allegation?
Again, I would direct that question to company witness Sullivan.
Okay. And in 2017, it found that 12% of Pepco contracted out workers were making less than the DC minimum wage. Would you give me the same answer to that finding?
Yes, I would.
Okay. Now, you acknowledge this letter that we're looking at, which I asked for it to be marked as BWLDC Cross Exhibit 1. That this letter is written in 2017?
It was dated October 2017. That is correct.
Right. And this letter was sent in response to a commission request. Isn't that right?
Yes, it was.
Right. And the commission made the request because workers had complained at a public hearing about not receiving DC minimum wage at that hearing. Isn't that right?
There were several employees that showed up to make comments at one of the public hearings.
Okay. So this is 3 years ago. 3 years and 3 days, right?
Yes.
Okay. And in that time, since this letter was written, has Pepco conducted any audits of its contractors for compliance with minimum wage?
It's my understanding that we have.
Okay. Do you know if those audits were referenced in this data requests responding to BWLDC?
I don't believe I sponsored very many data requests, but I would not have provided that information. I was not asked the question. So I'm not sure if company witness Sullivan had provided information or not.
Okay. Would he be the appropriate person to ask that question to?
Yes.
Okay. Thank you for that. All right. All right. If there were a PIM as proposed to provide an incentive to Pepco to address this issue, do you agree with me that would be a way to provide an incentive for Pepco to utilize its tools more frequently?
The fact that if the company audits a contractor and finds out that that contractor is in violation of federal, state, or city laws, regardless if it's wage or something else, we have the right to terminate that contract and terminate a relationship with that company. I believe that gives the company, the contractor, great incentive to ensure that they comply with those laws. So I don't think a PIM adds much to that, and I believe that the enforcement rights in the terms and conditions of our contracts is a pretty good incentive.
Let me ask you that. Do you know if Pepco has ever terminated a contract with a contractor due to finding that the contractor was not complying with DC's minimum wage?
I don't know that answer.
Okay. And I'm just going to move on to another topic, which is the provision of health insurance coverage by the contractors to the contracted out workforce. And again, in Steve Lanning's Sir rebuttal testimony, he testified that only 41% of the contracted out workers were covered by health insurance, leaving 59%, so nearly 60% of the contracted out workers not covered by health insurance. Now, this was in 2019, so it was before the current pandemic. But are you aware of anything that Pepco has done to try to increase health coverage for this group of contracted out workers?
I don't know specifically. I mean, just to be clear, the company hires a contractor to perform a service, and we, as part of that evaluation, we try to find a contractor that is obviously qualified, that aligns with our corporate values, abides by all federal, state, and city laws, and gives us a good price for the work. We don't try to micromanage their business, and in trying to get involved with what health insurance or what salaries that they should be providing, that's just not the role that we take. It's important for them that they abide by all those rules, and we have terms and conditions, and as you pointed out, have enforcement rights to ensure that they're complying with that. But to actually micromanage a contractor's business is something that we don't do.
Right. And when you say micromanage, would you say that encouraging those contractors to provide health insurance coverage to their employees is included in micromanaging them?
We hire a contractor to perform services, and we hire companies that we believe are responsible and will make the right decisions on those.
Right. Do you believe that ensuring health care for the contracted out workers is relevant to promoting safety and reliability in Pepco service?
I think what promotes safety and reliability and Pepco's customer service is hiring contractors that can perform the work under the specifications that the company provides.
The current
Excuse me. Sorry to interrupt. This is Chairman speaking. I'm giving you a little bit of leeway with the time allotted. I just wanted to get a sense of how much more time do you think you need?
One more question, Your Honor.
Thank you.
During this pandemic of COVID-19, do you believe that the health emergency caused by the pandemic affects your prior answer regarding whether or not health insurance coverage is important to promoting the safety and reliability of Pepco service?
Well, I agree that providing health coverage is important for the health and well-being of employees and individuals. What I would say is in order to promote the safety and reliability of Pepco service, hiring the right people, training our employees to do the job every day they do, that's what drives reliability and that's what drives performance of our system.
Thank you, Mr. McGowan. Appreciate it.
Right. Thank you.
Thank you. We also, the commission, I have two brief questions. If we can take care of this now, and then after the commission is finished with its questions and we deal very briefly with exhibits, we will break for lunch. So my first question, Ms. McGowan, directing your attention to your direct testimony, page 4, lines 7 through 12. Please let me know when you get there.
Okay, I'm there.
There's no need for the commission secretary office to put up.
I'm there.
You state the company is actively engaged with our customers to understand how they are changing the way they use energy, working with stakeholders on the development of policy to address environmental, resilient, societal, and economic goals important to the District of Columbia, and focused on meeting customers' needs and increased expectations around climate change, sustainability, and the installation of distributed energy resources. Is that right?
Yes, sir.
Now directing your attention to what has been preliminarily marked as Commission Exhibit number 17. There is a commission staff has compiled a snapshot of DC distributed energy resources, including resource type and total megawatts. Do you see that?
Give me one quick second.
And I have a quick question that you don't have to answer right now. So if you would accept subject to check that this is a snapshot, I'll ask my question.
Okay, I have the exhibit.
Excellent. Can Pepco update, amend, and confirm the numbers listed in this exhibit provided by the commission? And we believe it would be nice, it would be helpful for the commission to have a good baseline for DER in the district. Could you do that for the
Absolutely. Be happy to.
Thank you. My next question, and hopefully my final question, you testified on cross-examination that if approved, the Pepco's enhanced MRP proposal will only cover years 2021, 2022. Is that correct?
It covers the 3-year period, but there's only 2 years remaining left on the MRP. Yes.
Right. Thank you. So given that the offsets will end in the year 2022, Does Pepco have any proposals that it can put to the commission to address the possibility of rate shock in 2023? And again, you don't have to answer this question now. If you can take it back and provide it to the commission as soon as possible.
I would like the opportunity to think about that and come back with a response. I appreciate that opportunity.
All right. Thank you. So with that,
Chairman, if I could, because we didn't get a chance, if we could move into the record those exhibits marked as Pepco Exhibit 1 through 5 with represent the testimonies plural for Mr. McGowan.
yes, without objection.
Thank you. And in addition, we also noticed that DCG did not get a chance to move or walk through all of their cross exhibits, which were DRs. And we want to let the commission as well as DCG know that Pepco is more than willing to stipulate to these DRs. So again, we can ensure that we have a robust and comprehensive record.
We thank you, Mr. Hassan. Moving on, let me.
Thank you. This is,
DC government.
no, so yeah, this is Brian Caldwell, DC government. I was gonna, before we break, move for the admission of the exhibits that I introduced. I just have a question for counsel for Pepco if she's agreeing to stipulate to all the exhibits that were preliminarily identified, but we didn't get a chance to discuss.
That is correct, because it seems like you wanted to have that opportunity to discuss all of the DRs that you proffered as cross exhibits.
Okay, well, I think I need to think about that. If that's I don't want this to be like a quid pro quo in exchange for.
That's not that's not our intention by all. Again, our purpose is to make sure we have an appropriate and complete record before the commission. I'm not looking for an exchange with the DCG on this.
Let's do this. Let's take a break. I would love for Ms. McGowan to be dismissed.
Wait,
one moment. Before we do exhibits, but I believe I'm going to give everyone an opportunity to break for lunch, consider your exhibits, and then we come back, move all of the exhibits that need to be moved into the record after lunch, and then Mr. McGowan will be dismissed. Ms. Francis.
Just before Mr. McGowan is dismissed, I'm looking at my notes. I think I may have misspoke. I would just like to make clear, put on for Mr. McGowan what AOBA asked him if he would be able to provide. And specifically, I am asking for the base distribution rate increases that the average customer in each commercial class will experience as of January 1st, 2023, without consideration of BSA charges. That is what I meant to say. I think I misspoke.
Thank you for the clarification. It is noted for the record and also encourage the parties to definitely talk as they can during the break. So with that, we will take it is now on my clock, 1:13. Let's say we'll come back at 2 o'clock for lunch. Take a 45-minute break. We're now off the record in FC 1156 until 2 p.m.
If I may, if everyone could not.
I can't hear Carmen. If Carmen is speaking, I can't hear her.
Yes, I'm sorry. If I may, if everyone could not disconnect from the Zoom, but rather just turn your cameras off and make sure your audio is off.
One question, Carmen. I received some emails from you about, I guess, clicking on something, a program or something, but I don't think I can do that without getting off of whatever I'm on.
Okay.
Can I do that later today?
Yeah, I'll reach out to you momentarily.
Okay, do you have my phone number?
Yes.
Thank you, Carmen.
Okay.
Good afternoon. We are now back on the record in formal case number 1156. The time is 2:01 p.m. I believe we have just a few more matters to deal with regarding witness McGowan. At this time, I believe we will entertain the parties to an opportunity to move in their exhibits into the record. We'll start with the company.
Thank you, Your Honor. Pepco would ask that the commission move into the record the exhibit marked Pepco 1, the direct testimony of witness Kevin McGowan. Pepco also requests that the commission move into the record the exhibit marked Pepco 2, the supplemental direct testimony of Kevin McGowan. Pepco requests that the commission move into the record the exhibit marked Pepco 3, which is the second supplemental direct testimony of company witness Kevin McGowan. Pepco also requests that the commission move into the record the exhibit marked exhibit Pepco 4, which is the rebuttal testimony of Kevin McGowan. And finally, the company requests that the commission move into the record the exhibit marked Pepco 5, which is the rebuttal testimony of Kevin McGowan.
Without objection. Office of People's Counsel.
Yes, Your Honor. I believe the only document we had was our cross exhibit, Exhibit 1, which I think you had previously admitted.
That is correct, sir. Thank you. District Government.
I think Aoba had some.
You're right. I got out of order.
Okay. Don't forget me.
Ms. Francis, I cannot forget you.
Thank you, Your Honor. I would like to move the admission of AOBA cross-examination Exhibit 1, labeled as AOBA 1, which is the DCPSC docket PEPSAR and formal case number 1139, Pepco BSA report filed October 12th, 2020.
Thank you. Mr. Caldwell. With that,
Thank you, Your Honor. At this time, the district government would like to move into evidence what has been identified as DCG 1 through DCG 6. And regarding the offer, Pepco's offer to stipulate to the rest of the exhibits that were preliminarily identified on our list for Mr. McGowan. We will continue to work with Pepco to try to work out an arrangement, perhaps a list of stipulated to exhibits throughout this proceeding. For filing at the end of the proceeding if we can.
Could you repeat that for me, please, and make sure I understand? You're proposing that you work out a list to be filed at the end. Is that what I heard?
Correct. We will work with counsel for Pepco to formulate a list of stipulated to jointly stipulated to exhibits for admission at the end of this proceeding.
That's acceptable to the commission. All right. So without objection, that is acceptable. And Lyona.
I'm going to move for the admission of what was marked as Exhibit 1, the letter written by Pepco.
You broke up a little bit, but I believe you were moving the letter that was written by Pepco that you examined the witness on. Without objection, that letter is admitted as your exhibit number 1.
Thank you, Your Honor.
Okay. All right. With that, are there any other exhibits that need? Okay. So,
Chairman Phillips.
Yes.
Sorry, this is Anjali Patel from OPC. Well, we don't have any exhibits. We did want to raise one issue of concern. Based on the discussion prior to the break, it sounds like the chairman has asked for what appears to be a new proposal or an amendment to Pepco's proposal. We're just worried about the due process concerns with getting a new proposal at this point in time. So we're wondering what you were thinking in terms of how the parties would be able to respond to what Pepco puts in the docket regarding offsets for 2023. Thank you.
No, thank you. I'm absolutely not asking for a new proposal. I'm simply asking what, if anything, the company had considered with regard to rate shock regarding the end of the offsets. If there isn't anything, then there isn't anything to consider. The commission is very concerned about the issue. And so we're just simply trying to gather information that can assist us in our determination on the issue.
And thank you. We appreciate that sentiment. As you know, OPC is also very concerned about rate shock and the impact of this case on ratepayers. Does the company have an idea of when it will be able to provide that response to the commission?
The commission has asked for it as soon as possible. In practice, we assume that will be within a few business days. If that's not the case, Pepco can please correct the record. All right. I can barely hear you, sir.
Can you hear me now?
Better, yes.
Okay, sorry about that. So on the issues to address the rate adjustment in January 2023, we would commit to have that to the commission before the end of the week.
That is acceptable. Thank you. OPC, Office of People's Counsel, is that acceptable?
That is acceptable. Thank you.
All right. Okay, so Mr. McGowan, I believe you are free to go, sir.
Great, thank you. I did have two quick follow-ups to the requests that were asked during my cross-examination. First, on the updated DER schedule, we will commit to get that to you by end of week as well. One request is if you could have staff email us that document that you were referring to, because we don't have a version that we can work from. That would be helpful. And then Mr. Strauss asked questions on the public notice around what happens with rate in year 4. And so what we'll commit to doing is take the format of the public notice, add a 4th column to keep the format the same and show what the rate will be for customers in that year 4 once the offsets expire. And we'll have that by end of week to the parties if that's acceptable to OPC.
Does that include all customer classes?
Yes, it will.
Thank you.
All right. Nothing
further. Can I be heard on that, Your Honor?
Sorry. Please identify yourself.
It says Scott Strauss for OPC. I just want to be clear. I thought Mr. McGowan had said that the information I requested was in either Mr. Blazunis's testimony or his work papers. If it is in neither place, I would appreciate knowing that. I was going to ask Mr. Wolverton about this as well, as he obviously does a fair amount of testifying about rates and rate impacts and so forth. I don't want to waste time if the information is not there and will be provided initially at the end of the week.
Yeah, I would just direct that question to probably Company Witness Blazunis or Company Witness Wolverton.
All right, I'll ask Mr. Wolverton then.
Okay.
Thank you.
Thanks.
Okay, thank you. All right, with nothing further, you are dismissed. The witness is dismissed.
Great, thank you. Be safe.
Okay, thank you. So before we take up the next witness, the commission is prepared to address the motion that was made at the top of the hearing regarding the DRs that are not in the record. This was a motion by Pepco. The commission asked the parties to, in the hopes of limiting the scope of this proceeding, to identify those issues that were material issues of fact that were in dispute. The hopes that we would get something that was very limited, that we could handle in a very efficient manner, given the long time that this proceeding has been going and everything that is on the record. The parties came back with over 372 material issues. To, I will be honest with you, my extreme disappointment. giving the parties the benefit of the doubt, we have now allowed those issues that are relevant to the testimony that is before us to proceed, because this is an unprecedented case for the commission. And because of that leeway that we have granted the parties, the commission now feels that it would be unfair to not allow the company to then put on the record also information that they have addressed in their testimony, DRs that they have addressed in their testimony, in order to address those very many issues that are relevant. So due to the unique circumstances of this proceeding, the commission is going to allow the company to submit the DRs as identified, those that are mentioned in their testimony and relevant to this proceeding. So with that, we now will allow the company to call its next witness.
One more question, Your Honor, because the company's request was twofold, and that second part of our request was that any DR that's admitted into the record will be admitted in its entirety, as opposed to a portion.
Yes, we understand. Motion is granted.
Thank you, Your Honor.
Your Honor, this is Anjali Patel from OPC. We understand the commission's ruling with respect to the DRs in Pepco's testimony, but with respect to the second request to expand the DRs and add in every attachment that is attached to them, we request an opportunity to brief the specific requests, each of the Pepco specific requests. We provided you with our general objection, but the list has 33 different data responses with hundreds of documents attached to them, and many of them are irrelevant to this case. Pepco has not laid a foundation as to why they should be admitted to the case, why they're relevant to the case. And if we're not going to go through them here, we'd request an opportunity to provide you with specific objections to each one.
The commission takes your objection under advisement, and at this time, our ruling stands as is. With that, company, please call your next witness. If you're speaking, I cannot hear you. I see the witness coming.
My apologies. I needed 1 second to wipe down my station.
Yes.
Thank
Please
you.
be safe.
At all times, yes, sir. All right, my turn.
Mr. Warburton, are you ready?
Yes.
Can you raise your right hand, sir? Do you swear or affirm that the testimony you're about to give in this proceeding is nothing but the truth, sir?
Yes.
Thank you.
I think my attorney is getting set up, so just a couple seconds, sorry.
Please, and if you would please move the microphone as close to your mouth as possible.
Is that better?
Much better, thank you.
Okay, great.
Has your counsel abandoned you,
Yes, can you hear me, Mr. Chairman? This is
Yes.
Terry Bellamy on behalf of Pepco. Sorry for the delay. We're just switching out workstations so that we can sanitize everything. So
Thank you.
I apologize. And I can't see everybody. Okay, we are ready. Whenever council is ready. And let me start with the introduction of Mr. Wolverton's documents and Mr. Wolverton himself. Good morning. Good afternoon, rather, Mr. Wolverton. If you could please state your name and your job title and the company for whom you work.
Tyler Wolverton, Manager Revenue Policy for Pepco.
And do you have before you your pre-filed testimony in this matter, which is numbered direct testimony, Pepco C, supplemental direct testimony, Pepco 2C, second supplemental direct testimonies, Pepco 3C, third supplemental direct testimony, Pepco 4C, your rebuttal testimony, Pepco 5C, and I am plugged in, aren't I? My headset is plugged in. It's just not working. You want to come check it? Thank you. I'm sorry, Your Honor. Your rebuttal testimony, Pepco 5C, your surrebuttal testimony, Pepco 6C, and your fourth supplemental testimony, Pepco 7C. And my staff is telling me that my headset is not plugged in, and I will figure out why, or he will help me figure out why.
We can hear you.
We can hear you clearly, Ms. Bell.
Can you hear me?
We can hear you. I can.
All right. Thank you very much, sir. Do you have those pieces of testimony and their attachments with you, Mr.
Yes. Yes, I do.
Mr. Wolverton? And if I were to ask you, have you identified any corrections that need to be made to any of those pieces of testimony to which we just referred?
Two minor corrections. So in my rebuttal testimony, Pepco 5C, page 10, the bottom of the page, footnote 6, it should reference OPC B5, page 1, and not OPC B3, page 1. So that's the first one. And then the second one is in one of my exhibits, my surrebuttal. So Pepco 6C, exhibit 1, 6C1, page 3 of 67.
Please help me here.
I'm just going to wait 1 second.
We're having some technical challenges. I'm sorry. All right, I think this should be good. Can you hear me? Tyler, please say something so I can tell if I can hear you.
We can
Excellent.
hear you. Yes.
I apologize. I apologize, Chairman. Chairman Phillips. Okay. And those corrections were...
Sorry, Sherry, I didn't finish the corrections yet.
Let's do that again.
Okay.
Thank you very much.
Okay. So the second correction was in my exhibit, Pepco 6C1, page 3 of 67. In the footnotes, footnote 1 and 2 both reference a Pepco 3E1 exhibit, but they both should just say Pepco E1, not 3E1. And that's it.
And with those corrections, is the testimony you've just referred to, would the answers, that if I were to ask those questions again, would your answers be the same?
Yes.
So do you adopt those as your testimony in this proceeding?
Yes.
Chairman Phillips, this witness is available for cross-examination, and we will mark his exhibits at the end, C through 7C. So I'm not sure what our exhibit numbers are, what numbers we're up to at this moment.
We'll get it straightened out at the end of the, this witness has been tendered and is available for the Office of People's Counsel for cross-examination.
Yes, thank you, Your Honor. Good afternoon, Mr. Wolverton. I'm Scott Strauss. I'm going to ask you some questions on behalf of the Office of People's Counsel.
Good afternoon.
Let me start by following up on a question that Mr. McGowan flipped to you this morning. If the enhanced MRP is approved, but the revenue requirement approved by the commission turns out to be less than the amount proposed by the company, would Pepco then adjust downward the amount of customer offsets it's proposed?
So with the enhanced MRP proposal, the offsets in 2021 are meant to fully offset the revenue requirement increase in 2021. And the offsets in year 2022 are meant to partially offset the revenue increase. So to the extent that the revenue increase is reduced, there would be an offsetting reduction to the offsets.
Right, an offset to the offset, in other words. Is that
right, that's right.
All right, so let me ask you this. If the commission reduces the revenue requirement to the point where the impact of the rate increase can be offset in full without the use of an entire category of the proposed offsets, has Pepco established an order of operation in which those offsets would not be used?
So partially, I think that that's up to the commission's preference to some extent. I would say there's really four categories of offsets, right? So the first category is the sort of shareholder funded offsets, right? And I'll call those the residential rate delay. I think it's about $25 million, and then there's an additional $3 million related to the customer base rate credit. Those offsets are really a delay. They're meant to delay residential rate increases. So to the extent that rates did not go into effect as of October 1st, obviously that didn't happen. And, you know, I don't know exactly when rates will go into effect, but those benefits are really not needed to offset an increase that hasn't happened. So that number would go down just sort of naturally, okay? The second category is a pause to regulatory asset amortization expense. Third category is an acceleration of excess deferred income tax amortization. And the fourth category is an acceleration of additional subtraction modification liability amortization. To the extent that you wanted to eliminate an entire category, you could choose the you're not on mute. You could choose the amortization expense. The staff offered that up in a data request, and asked what would the scenario look like if all of the amortization expense pause was not provided. What Pepco has basically done in terms of an order of operations type of question is really that excess deferred income tax is what gets adjusted. So the amortization sort of is what it is. Then the excess deferred income taxes are adjusted, and then to the extent that there were additional benefits needed to get close to to have a larger mitigation in rate year 3, we used the additional subtraction modification. Hopefully that helps.
It does. Thank you. Thank you. I'm sure when I read the transcript, it will. Let me ask another question. Another one that Mr. McGowan was unable to answer. You're the manager, I think you said, for revenue policy. Do you know by what % distribution service rates for residential customers will increase as of January 1st, 2023, when the offsets expire?
I don't have that number offhand, but it should be a number similar to the increase on January 1 of 2022, because I think that the reduction or the offset was about 50%. Mr. Blazunas can provide that exact number when he comes on the stand.
Is it roughly the same because the revenue requirement increase for each of those years, 2022 and 2023, are sort of relatively close to each other?
The way that Pepco looks at it is we have a $135.9 million increase in 2022 that's offset by the rider ERR. once that, which is it's a little, I think it's a little less than 50% of the total of 135.9 million. Once that rider ERR expires at the end of 2022, the base rates just sort of are what they are at the $135.9 million level.
Okay. So actually, that was another question I had. So the rider ERR ends as of the beginning of 2023.
Correct. It's in place for 2022.
Thank you. Do you think that the percentage increase in distribution service costs as of January 1, 2023 is relevant to the Commission's consideration of the issues in this proceeding?
Yeah.
I'm sorry, I didn't hear.
Objection. Relevancy is really up to the determination of the commission, not to this witness.
I didn't ask whether the commission considered it relevant. I asked whether the witness considers it relevant. Does the witness think it is relevant here?
My objection stands.
Please rephrase the question, Mr. Strauss.
Sure. The percentage increase in distribution service costs, sir, do you think that piece of information is relevant to the commission's consideration of the issues in this case?
I think that there's a lot of relevant pieces of information, and to that particular item, I think that the company has already pretty much quantified that, because all that this is the expiration of the rider ERR. So to the extent that there's a rider ERR in 2022 and it goes away in 2023, that information is on the record.
Is it possible, Mr. Wolverton, that Pepco will in 2022 file a rate case that will propose an increase in distribution service rates that is even larger than the one that will be implemented in January 1st, 2023 under the MRP enhanced proposal?
Objection. Calls for speculation, and even larger than, I think that's speculative.
I agree.
Perhaps counsel could rephrase.
I'm sorry, did you rule, Your Honor? I didn't hear you.
Yes, sustain. It does call.
You did. Okay.
Witness, is it possible? That is the definition of speculation.
Mr. Wolverton, do you know whether Pepco will file a rate case in 2022 to adjust rates as of January 1st, 2023?
I don't know that we will. I think it depends on the outcome of this rate case, and if the commission wants to move forward with the multi-year rate plan and what the ultimate outcome is of this proceeding.
Okay. If you could turn to your rebuttal, which has been marked for identification as 6C. I'm not sure what number it is at the moment. Your most recent rebuttal, I'm looking at page 14.
Sure. Just 1 second. You said page 14?
Yes.
Yes, sir. I'm there.
All right. So at this page, you discuss that there will be 3 reconciliation processes that will be implemented in which Pepco's projected and actual costs will be compared under the enhanced MRP. Is that correct?
Yes.
Okay. And the first process that you identify, I believe, is the submission of an annual information filing, correct?
Correct.
And then over on page 15 of your testimony, you address the content of that filing, correct?
More or less the content. I think it's sort of a comparison of what was originally proposed in the original MRP proposal versus what this is, but sure.
Right. Okay, fair enough. Now at lines 9 to 11 there on page 15, you state that to the extent the filing shows that Pepco is over-earning, customers can file a petition with the commission seeking a rate reduction. Is that correct?
Correct.
And how soon after the information filing is made would the customers have to file such a petition, sir?
So I think we've generally left timelines up to the commission's discretion to some degree in this proposal. But I can tell you under the Maryland, what the Maryland Commission has approved, which this has been modeled after, the company would file this annual information filing 90 days after the end of the test period. And then there's a 60-day period for discovery and comments. So I would imagine that that request would be within that 60-day period.
Well, actually, you've anticipated another of my questions. You don't cover it here, but will the customers have an opportunity to seek discovery on this filing?
Yes.
And if the company refuses to answer a discovery request, do you envision that the customers will be able to come to the commission for an order directing that it do so?
I'm not sure that we would refuse to answer a discovery request. That seems something we wouldn't do.
It does happen in cases time to time, sir, I assure you. If that were to happen here, do you envision the customers could go to the commission for an order directing a response?
I don't know.
If the customers file a response sometime within those 60 days, do you envision that the company would want to have an opportunity to reply to that response? I'm sorry, to the petition, excuse me. Let me rephrase that again. If the customers file a petition within that 60-day period you described, envision that the company would want an opportunity to answer that petition.
In Maryland, I believe that the way that the commission has approved this in Maryland, which again we've modeled this after, is that there's this 60-day period, and let's say on day 60, the other parties, the parties file comments. The commission would evaluate those comments, and then there would be they would initiate evidentiary hearings if necessary.
Okay, so that was actually, you anticipated another of my questions, sir. This annual information filing, depending on what petition was filed and what issues it raised, you could end up with an evidentiary hearing about the petition. Is that correct?
That would be up to the commission, yeah.
Okay. And then on page 15 at lines 11 to 13, you state that if the annual information filing shows the company is under earning, the company cannot seek an adjustment as part of the filing. Is that correct?
Correct.
All right. Well, then at the bottom of page 15 and then over to page 16, you refer to a final reconciliation that covers all three MRP enhanced proposal years. Do you see that?
Yes.
And you say on line 20 that the reconciliation amount to be considered will be subject to a prudency review. Is that correct?
Correct.
Pepco will be able in that filing to request recovery of any alleged under-earning that the company contends it experienced during the period that the MRP is in effect. Is that correct?
Yes, with no carrying costs on any under-earnings.
All right, and would the customers have an opportunity when that filing is made to have discovery concerning that filing?
Yes.
And if the customers filed an objection, I assume the company would want an opportunity to respond. Would that be correct?
Yes.
And you said that this filing could involve prudence issues. Is that correct?
Yes.
And prudence challenges are often highly fact-specific, are they not?
I think that generally the commission has certain standards that it's used in the past for prudency reviews, and that the commission would determine what the specific standard was for this filing. But I think in the past, generally, Pepco has been judged on sort of what it knew or could have known at the time an investment was made. So you could say it was specific to the facts of a particular instance.
Sure. To the point, if a prudence challenge was asserted, the commission might need to convene an evidentiary hearing in order to resolve it. Isn't that possible?
Yes.
And then on page 17 of your testimony, we could turn there for a moment. At lines 6 to 12, You did discuss the possibility that amounts could be placed into a regulatory asset or liability to be addressed in a rider and recovered. And you say this would be determined on a case-by-case basis. Do you see that?
Yes.
And again, case-by-case determinations could require additional filings by both sides, right?
I think ultimately the commission would determine the time frame and procedural schedule for any filing like this, and I think that's sort of what we've tried to leave this a bit open-ended and up to the commission's discretion instead of being as prescriptive on what the timeline might be.
Right. Although to be clear, again, as a case-by-case determination, it's possible the commission could order a hearing, correct?
It's possible.
Okay. Now turn back to page 16 of your Sir rebuttal, sir. I'm focusing on the question and answer at lines 2 through 10, where you discuss the consolidated reconciliation and prudency review in the next rate case. Do you see that?
Yes.
There's a footnote on page 16, footnote 34, which mentions the possibility that Pepco might file a rate increase in 2022 to become effective in 2023. Do you see that?
Yes.
If that happens and the consolidated filing is made, then would I be correct that in the company's next rate case, the commission would be considering both the prudency of costs incurred during the multi-year term of the current MRP, as well as rates for the next MRP?
The commission would be considering the rates for the next MRP clearly, and the in this specific instance with a 2022 consolidated reconciliation, it would be considering the 2020 sort of results of this MRP through 2021 versus what Pepco had projected.
Okay, I think the answer to my question was yes, but that's fine. I have a document I'd like to have admitted. It's a data response. It's the response from the company to staff 26-5. We could bring that one up. And Mr. Wolverton, I don't actually need to ask you any questions about this question and answer. I simply would ask you, if you were asked the questions here today, would your answer be the same?
Yes, the only thing I would like to add is that, you know, this does indicate that we would not file an annual information filing with respect to 2020 results because it's unlikely at this point that there will be a multi-year rate plan in effect for 2020. I would just note that we do have annual and quarterly earned return reports that Pepco files on a quarterly basis with the commission, and we would be filing a 2020 quarterly earned return report probably in the April or May timeframe of 2021 that would provide our actual 2020 results, so that the commission would still have line of sight into 2020 results, even though there was no MRP in effect for the 2020 year.
And with that addition, your answer would be the same?
Yes.
Okay. Your Honor, I'd like to have this marked as OPC Cross Exhibit 2.
So mark.
That's all I have, Mr. Wolverton. Thanks very much.
Thank you.
We thank the Office of People's Counsel. Next up, I have Aoba.
Am I unmuted? Can you hear me?
Yes, we can hear you.
Okay. Your Honor, I have no cross for Mr. Wolverton. However, AOPA just became aware of something that I want to inform the commission. At the present time, the parties have stipulated the testimony of witness Tim Oliver. Mr. Bruce Oliver is on the list for tomorrow. However, I have just been informed that Tim Oliver needs emergency surgery right now, and he will be in the hospital for 2 or 3 days. I don't know if the commission had any questions for him. And while I haven't discussed this with witness Bruce Oliver yet. I believe that witness Bruce Oliver would be able to respond to questions from Mr. Tim Oliver. It may not be an issue, but I wanted the commission and the parties to be aware of that.
Thank you. Thank you, Ms. Francis, for bringing that to our attention. First of all, most importantly, our thoughts are with Mr. Tim Oliver, and we have a speedy recovery. The commission does not have any questions for Mr. Oliver, so that will not be an issue from our perspective. However, I offer the opportunity for the other parties to speak up now if that is an issue for them. The company to speak up now. Hearing no objection, I believe it's fine.
Thank you, Your Honor.
It is fine. I'm sorry, Your Honor. Yes, it is fine. I had a difficulty turning off the mute.
I understand. Okay.
Thank you.
Your Honor.
All right. Thank you. No cross from AOBA. We're moving right along to the district government. Mr. Caldwell.
Yes, Chairman Phillips, thank you. Just a few questions. Good afternoon, Mr. Wolverton. Do you have in front of you a copy of the district government list of cross-examination exhibits?
Yes.
Great. Please give me one moment to try to pull this up again. Can you please bring your attention to what was preliminarily marked as Exhibit DCG 50, which is the company's response to District Government Data Request 6-15?
I have it.
Right, and the question is in reference to your direct testimony, specifically an exhibit attached to your testimony, which was Exhibit C-5, which is intended to provide a sample of what a reconciliation filing might look like. Is that correct?
That is the purpose of C-5. I'd just note that we made some clarifying statements and some modifications to C5 or to what would be included in that reconciliation in my rebuttal testimony.
Okay. But this is an example of a filing that the company would make to demonstrate to the parties that either certain classes or categories of expenditures were or were not within a variance threshold or percentage level between what was projected and what was actually spent. Is that correct?
Just give me one. I just want to turn to the exhibit. So, yeah, I mean, what this is doing is what we'd basically be doing here is lining up what were we projecting to our results to be in a given multi-year rate plan year from a earned return on equity standpoint. And you can see if you're looking at my Pepco C5, we have all the rate base items, all the revenue and expense items, and then we would line that up next to the actual results for those same items, calculate a dollar variance and a percentage variance, and then to the extent that those variances met a certain threshold, we would provide a description of the variance, and then I just want to couple little additions. The second and third pages of that report are around, or of that exhibit are around our operation and maintenance expense, and that is at the account level. So we sort of have a more detailed breakdown of our projected versus actual O&M expense at the FERC account level. And then in my rebuttal testimony, I described that we would provide an additional exhibit that showed our projected versus actual plant additions at the project specific level, and would provide variance analyses to the extent that there were variances that met a certain threshold.
Okay. And that and the variance, the percentage for the variance at the project level
For the capital?
Yeah, correct.
So I described that on pages 6 and 7 of my rebuttal testimony, Pepco 5C. So basically, what we had initially proposed in Pepco C5 was that for plant and service, if there was a 1% variance in our plant and service balance between projected and actual results, we would provide a description of that. And I think we heard from the parties that, you know, that they had some concerns with this. So we tried to address that in rebuttal testimony. And what we said, again, is that we would provide this more detailed schedule that showed actual plant additions by project versus projected plant additions by project, and that we would provide variance descriptions sort of in 3 categories. First would be kind of 1-to-1. So if there were dollars projected and then there were dollars spent for any project where there was a greater than $2 million variance, we would provide the a description of that variance in that category. And then for new projects, meaning the project, you know, wasn't in our projections that we filed in this case, but we did undertake it, we would provide a description to the extent the project was larger than $1 million, and to the extent that we canceled or delayed a project, meaning that there were dollars in our multi-year rate plan, but there are no dollars in actuals, we would provide a description if the project was greater than $1 million, or sorry, if the variance was greater than $1 million. So not a percentage, a dollar threshold for that.
And the company still is proposing, if there is if the amount spent turns out to be in excess of the variance per percentage, that it would provide a detailed narrative of the variance. Is that correct?
Yes, that is correct. And I should be more clear on the capital piece of it. These are plant additions. So it's not necessarily you know, what happens with a capital project is you spend the dollars, it's capital expenditures, but what goes into rate base is when those projects are completed. So these are more the completions of projects. So we projected that we would put this much amount of a project, or we would put this much in service, and we actually put this, you know, X amount in service. But the answer is yes, we plan to provide this, including in the enhanced MRP proposal.
Yeah. So it would be incumbent then upon the parties, if to the extent that there was any sort of excess, and the variance the amount can change depending on the project that we're talking about, correct?
I think every project, there's a different projected amount of spending and a different you know, amount that would actually go in service. So yeah, every project would have a different amount of you know, a different dollar value associated with it. But these I think your question is, if there's a variance that does not meet this threshold, the parties have to ask discovery on that. Is that what you're saying?
Correct.
Yeah, the answer is yes, and you know, our intention here is that this type of variance analysis would provide parties with the vast majority of the you know, the total variance. So that's how this was designed.
Right. And so that's how prudency would be assessed based on each individual project, to the extent that there was is the variance meant to put it this way, is the variance meant to establish the various percentage threshold meant to establish prudency, or is it just meant to track the extent to which the project is staying on budget?
I think the variance thresholds are meant to sort of streamline the explanations of why actual dollars are different than projected dollars. That's what they're meant to do. You know, when we have a good deal of experience filing rate cases and providing, you know, some level of projected data and then providing actual information, and oftentimes we get asked about variances. So what we're trying to do here is provide a lot of that information up front. It should help with you know, determining how Pepco fared versus its projections. But in terms of prudency, you know, I think that's ultimately up to the commission and you know, the parties would do their, you know, whatever level of due diligence they feel is necessary. But this, you know, this is meant to be helpful.
Correct, and I believe you testify that prudency inquiries can be done in the course of approving an MRP as well as during the reconciliation process itself, correct?
Yes.
And to your knowledge, has a prudency review been conducted on any individual project prior to the approval of an MRP in other jurisdictions? Is that something that's typically done?
I mean, I think what's typically done in rate cases in general is, you know, there's a rate base and a level of expense that is reviewed by the commission and the parties, and you know, a revenue requirement is determined, and the parties do whatever, you know, diligence they do. They ask a lot of discovery, they file testimony, and that's sort of the purpose of the rate case process, both in a traditional rate case and in a multi-year rate plan environment.
But would you agree that once an MRP is approved and the projects that are in the MRP, that unless the project in the course of the reconciliation filing has gone, say, drastically under budget or over budget, that the question of whether or not it was a prudent investment has already, the ship has already sailed on that question, so to speak?
No, I wouldn't agree with that.
How would a party be able to determine whether or not a project is prudent after it's already been, an MRP has already been approved?
I mean, that's the, I think that's generally what happens in a traditional rate case with historical spending.
Well, I think, that's all the questions I have. Thank you.
Thank you. I believe that is the last question from the parties. We do not have any cross from Lyona on this. The commission has just one question for the witness. Let's see. Directing your attention to your direct testimony, Mr. Wolverton.
Yes, sir.
36, lines 9 through 13. Let me know when you get there.
Sorry, lots of documents. Never had this much testimony in a rate case before. Okay, 7 pieces. Go ahead. Sorry.
Are you there?
Yes, sir.
Okay. You state the company will provide a reconciliation of all elements of rate base and earnings, including the difference in calculation of the revenue requirement impact. The proposed reconciliation would also include a reconciliation of the projected cost of debt and capital structure to the company's actual cost of debt and capital structure. Is that right?
Yes, I see that.
And I'm sure you are aware, and you can accept this subject to check, that the Exelon PHI merger commitment number 93, which is contained in order number 18160 attachment B, it states that Pepco shall maintain a rolling 12-month average annual equity ratio of at least 48%. Do you accept that subject to check?
I am aware of that particular item, so yes.
Thank you. What does the company recommend as an upper bound for the equity ratio during the MRP period, given the minimum equity ratio 48% as merger commitment number 93 requires? Should the commission approve Pepco's proposed capital structure in this proceeding?
You know, I think, unfortunately, I think Mr. McGowan would have been a great person to ask that particular question to. I can tell you that it's my understanding that the company targets an equity ratio in the 50% range, and I think it would be highly unusual for us to deviate significantly from that 50%-ish range. But beyond that, in terms of setting an upper bound, I'm not necessarily involved with our decisions around financing and equity offerings and that sort of thing around how we manage our capital structure. But I can say we do target an equity ratio in the 50% range.
I thank you for taking a stab at the question. And I have many powers, Mr. Wolverton, but I cannot go back into time.
Right.
Down. So to the extent that he disagrees with your estimate of around 50%, would you please correct the record for the commission?
Absolutely.
All right. And that concludes the questions for the commission. Unless Commissioner Beverly, I don't believe Commissioner Beverly has any questions.
I do not.
Thank you, sir.
All right. So at this time, we will turn to exhibits. We'll start with the company.
Thank you, Your Honor. Yes, Pepco would like to introduce, or excuse me, to mark as exhibit Pepco C would be Pepco exhibit number 6. Pepco 2C, supplemental direct testimony of Mr. Wolverton would be Pepco exhibit number 7. Pepco 3C, additional supplemental direct testimony of Mr. Wolverton would be Pepco exhibit number 8. 4C, the additional supplemental direct testimony of Mr. Wolverton would be Pepco exhibit 9. The 5C, the rebuttal testimony of Mr. Wolverton would be Pepco exhibit number 10. 6C, Mr. Wolverton's surrebuttal testimony would be Pepco exhibit 11. And then Pepco 7C, the supplemental direct testimony, I think it was the 4th supplemental direct testimony of Mr. Wolverton would be Pepco exhibit number 12. And I'd ask that those all be admitted into the record, please.
Without objection, they are admitted. Office of People's Counsel?
Yes, Your Honor, I'd move the admission of OPC Cross Exhibit 2.
Without objection?
Thank you.
Aoba? You did not have any exhibits. You did not have any cross. District Government?
No exhibits, Your Honor.
All right, and the commission, we did not have any exhibits. All right, Mr. Wolverton, you are dismissed. Have a safe and productive day.
Thank you.
And we now will ask for about an hour, actually. Let's pause. Let's take a 10-minute break. We will recess for 10 minutes, and then we will come back. We ask the party to be ready to go with company witness Zeminski when we return. 10-minute breaks. We are
sorry, Mr. Chairman. I don't believe any parties have questions for Mr. Zeminski. at this time?
I had on my list AOBA for 40 minutes.
Yeah, they have waived. So we have no, I don't believe Mr. Zeminski needs to take the stand unless the commission has some questions for him, but I don't know.
Let me check my list. I'm going to be very disappointed if we're the reason why we have to do this. I do not have any questions from Mrs. Zeminski. Thank you. I thank the parties for eliminating unnecessary questions. So who's your next witness that you'd like to call?
Well, Your Honor, Mr. Blasunas is our next witness. However, we just received some cross-examination exhibits for him today that he has not had an opportunity yet to review because, as we know, usually the witness has 24 hours. So I'm not certain if we want to proceed or, excuse me.
Let's do this. Let's break for 10 minutes.
Thank you.
Confer, I will confer with our staff to make sure that we are ready to proceed today. And I do not want to end early today. So to the extent possible, I want to keep going. But give us a 10-minute break and we'll be back on the record. Actually, let's go until 3:15. Let's recess until 3:15 and then we'll be back on the record. For now, we are in recess until 3:15.
Thank you. Thank you very much, Chairman.
Okay, everyone. We're now back on the record in formal case number 1156. Time is 3:15 p.m. We had before us, before we left, I'd asked the parties to put their heads together to come up with whether or not there were any more witnesses that we could take today that were ready to go.
And Mr. Chairman, the company is pleased to say that yes, Mr. Blasunas is ready to go today, and he is ready to take the stand in a moment. Also, if the commission chooses and if we have time, Mr. Descendis, I understand there was a question from the commission. He could be made available as well.
Well, thank you. We will ask the company to proceed when they're ready.
Your Honor, just so the commission is aware, previously AOBA had said they had questions for Mr. DeSantis and for Mr. Clark. We will not have questions for those two witnesses, but hopefully that'll help people with planning.
Thank you, Ms. Francis. Thank you, AOBA.
Okay.
I believe we have to swear, whenever the witness is ready, we'll have the commission secretary swear the witnesses.
Thank you. Are you on the screen? You should be on screen and off of mute.
Mr. Blasunas?
I believe he's in. Mr.
He's working his mute.
That's right.
Can you hear me now?
Yes.
All right.
Yes.
Sorry about that.
Raise your right hand, sir. Do you swear or affirm that the testimony you are about to give in this proceeding is the truth and nothing but the truth, sir?
I do.
Thank you.
Thank you.
Please proceed.
Thank you, Your Honor. Mr. Blasunas, could you please state your name and your job title and the company for whom you work?
My name is, certainly. My name is Peter R. Blasunas. I am the manager of rate administration for Pepco.
All right. And do you have before you your pre-filed direct, supplemental direct, second supplemental direct, rebuttal, surrebuttal, third supplemental direct, and fourth supplemental direct testimonies?
I do.
In this matter. And Your Honor, those are Pepco F, Pepco 2F, Pepco 3F, Pepco 4F, Pepco 5F, Pepco 6F, and Pepco 7F, to which there has been a stipulation for admission of all of those except for Pepco 7F. AOBA was reserving judgment on that one, and I believe I would need to walk Mr. Wolverton through the admission of 7F. Mr. Blasunas, I'm sorry, what did I say? I apologize. So, Mr. Blasunas, can you please pull out your testimony, Pepco 7F?
All right.
And can you tell the commission what Pepco Exhibit 7F is?
Yes. So this this testimony filed by me October 14th provides a summary of the demand billing determinant issue, and then it also provides a response to the second supplemental testimony of OPC witness Dismukes and a response to the second supplemental testimony of AOBA witness B. Oliver.
And if I were to ask you the questions that are posed in that testimony today, would your answers be the same?
Yes.
And was this testimony prepared by you or under your direct supervision?
Yes.
And do you have any changes or corrections to this testimony?
No.
Your Honor, I proffer Exhibit 7F, Pepco 7F, for the record.
Without objection.
Your Honor, I will be objecting to certain portions of the testimony being submitted into the evidence, but I'll wait till the appropriate time.
Noted. Thank you.
With that, Mr. Blasunas is available for cross-examination, Your Honor.
Office of People's Counsel. Mr. Gray, you're on mute. And also note that we are accepting 7F to the record pending the objections when we come to that time when we come to time to move them into the record. I think I got that right. Mr. Gray, proceed. You're on mute now.
All right, I'm having trouble with my computer audio. Is that better through the telephone?
Yes, better. We can hear you.
Okay, great. Thank you. My name is Jason Gray from the law firm of Duncan and Allen. Good afternoon, Mr. Blasunas.
Good afternoon.
Got a few questions that are going to focus on your October 14th testimony that was pre-filed as Exhibit Pepco 7F and your April 8, 2020 testimony that was pre-filed as Exhibit Pepco 4F. But before I get into that, I had a question that doesn't really fit anywhere in my outline, so I'll just ask it up front. Am I correct that you did not offer any written testimony on the topic of prudence?
On the top, sorry, prudence in what context necessarily?
Do you recall offering written testimony on prudence at all?
Not to my recollection.
Okay. And another housekeeping matter, I would just note, I am going to ask you some questions about your responses to data requests that are pre-filed in the record. They are attached to Dr. Dismuke's October 9th second supplemental testimony, which is marked as, or pre-filed as Exhibit OPC 5A, and then also one response that is in Attachment A to Bruce Oliver's October 9th supplemental testimony. Do you have someone in the room that can help you identify those documents?
Yeah, we can.
Okay,
we can get them.
All right, I will let you know when we're there. So let's start with your October 14th fourth supplemental testimony, Exhibit Pepco 7. Can you please turn to page 3 of that exhibit?
I'm there.
Do you see on line 12, you testify that in February of 2020, you were contacted by a member of your group at Atlantic City Electric and Delmarva Power about a potential issue with demand billing determinants?
Yes. So as I state, a member of my group who works for Atlantic City Electric and Delmarva Power notified me of a potential issue with the PHI demand billing variant report.
Sure, thank you. And after you were contacted in February 2020, am I correct that you performed your own analysis or your own investigation to confirm that the potential issue was in fact an actual error with that billing demand variant report?
So as a part of, upon being notified, I verified that it was indeed an issue for the company's traditional test period compliance filing in this proceeding for the actual billing determinants.
Okay, I don't want to quibble on semantics, but I just want to make sure the record is clear. Do you, when you use the term issue, if I use the term error, do you see a difference there?
No, sorry.
Okay. No problem. I just want to make sure that we're clear. So staying on page 3, at the bottom, line 19, you describe what that issue or error is. And over into page 4, line 4, you testify that the demand billing determinant report variant that Pepco has used since 2015 double counted demand in months where there was a time slice, and you defined time slice as a month where there were two price issues or two rates, such as a month within which a rate change occurs. Do you see that testimony?
I do.
Do you recall at the technical conference that was convened virtually in September, we had a discussion about a mid-month rate change in August of 2018, where the rates approved in formal case 1139 were replaced with the rates approved in formal case 1150?
I generally recall.
If you prefer to accept that subject to check, I'm just trying to establish an example of the concept. Assuming that is the case, would that month of August 2018, where there's a mid-month change, be an example of a time slice?
Yes, yes.
Okay, thank you. Keep your exhibit Pepco 7F in front of you, but I'd like you now to turn to the attachment A for Mr. Oliver's October 9th supplemental testimony on behalf of AOBA. And there are several responses in that attachment. I am just going to focus on one. It is the response to AOBA data request 9-2. It's on the screen. Your Honor, this is not my exhibit, but I was trying to not burden the record with duplicative exhibits, so I can mark this for Ms. Francis, or we can just leave the reference in the record to the document as it was pre-filed, or I'm happy to do anything else you prefer.
AOPA has no objection to just referring to it as attachment A, because we will be moving Mr. Bruce Oliver's testimony to the record after cross-examination. It's okay with Your Honor.
Pepco also has no objection.
Then I will allow it.
Okay, thank you. Do you recognize this data response, or excuse me, this data request as one that you received earlier this month and responded to?
I do. I am trying to open up to it at the moment, so give me 1 second.
Sure, yeah, let me know when you're there.
Which AOBA exhibit is this again? I apologize.
It's not an exhibit number, it's attachment A.
Attachment A.
And it's the third response in that.
Oh, the third. Okay, maybe that.
Which is a compilation of multiple responses.
Okay. I'm sorry about that. I'm getting there. So I should be at
9-2.
9-2. 42 of 64. Sorry, 1 second. I apologize.
No problem.
All right, apologies, I'm there.
No problem. Thank you. So I want to call your attention to the question and response to subpart C. The question asks to provide data and analysis, essentially documentation, to verify the existence of the need for the correction, and then the response is to the attachment thereto, which is the next page of the data response. Do you see that?
Yes.
All right. Focusing on the attachment, there's essentially 3 tables here. The top third, I understand, is the corrected billing determinants. The middle third are the erroneous billing determinants in the billing determinant variant report. And then the bottom third table is the delta between the corrected billing determinants and the erroneous billing determinants. Is that an accurate description of the attachment?
Yes. So the top table is the corrected demands. The middle table, the sum of the demands, which was the overstated demands, and then the bottom table is the difference. Yes.
Sure. Okay. Great. I want you to look in the middle column. Do you see the month of August 2018?
I do.
And that's the month we just discussed as an example of a time slice?
Yes.
Can you identify for any rate class on this chart where billing determinants are double counted between the corrected billing determinants and the erroneous billing determinants?
Could you rephrase the question?
Sure. I'm focusing on your definition of a time slice, or the error, on the top of page 4 of Exhibit Pepco 7F, where you said that there was a double counting of demand in months with a time slice. And so I am looking at this month of August 2018, and I don't see a double counting of demand. I see differences, but nowhere near a double counting.
Gotcha. So I think it's 2 things. So obviously the driver of the issue related to these time slices is not just the change in the distribution rates that occur in the middle of the month, but there are also other items that could cause a time slice to occur. So it's not the sole item. And then, as far as the other classes go, if I'm looking at, for instance, Pepco DC GSLV, between the actual demand, the top table, and the sum of demand, you see a difference of about 100,000 over 160,000. So while we've talked about before a double counting, it's not necessarily 2 to 1. It's just that in a period for certain customers, when a rate change was taking place, you would have a general overstatement of demands.
Thank you. You mentioned that the main driver is the change in distribution rates, but I believe you said there are other items that cause the difference. What are some of those other items?
The one other one that I'm aware of is like a cancellation and a rebill of a customer, and that can apply to individual customers as opposed to a whole class.
Okay, if you look at the next month, September 2018, that's a fairly substantial delta between the corrected billing determinants and the erroneous billing determinants in the middle column. Can we tell by looking at this chart what the driver is of that change versus one of the relatively smaller changes?
For September 2018?
Yes.
Yeah, I believe that's still carry through of the August change. So, not all our customers are on the same billing cycles. And so because of that, rate changes fall into various months differently.
Okay. So turning back to your testimony on page 4 of Exhibit Pepco 7F, time slice is a little bit more complicated in that there's not necessarily a double count, and it's not necessarily a month in which there's a rate change, but there could be other drivers or multiple months where there's a rate change. Is that an accurate way to sum it up?
I would say that double counting is probably, from a class perspective, too simple of a way to look at it. It's more
for an individual customer, when the report's pulling it, if there is a time slice, it's double counting it for that individual customer. Now, whether or not that all amounts to a double counting for the class is a different issue, because there are a lot of different things in the mix.
Okay, thank you, I appreciate it. You can put Mr. Oliver's exhibit down. We're not going to be turning back to that, so you can set that one aside. But please turn back to your exhibit Pepco 7F. And I want to call your attention to page 7. Let me know when you're there, please.
I'm there.
Okay, do you see the question on line 16? It asks whether you want to respond to any particular assertions made by OPC witness Dismukes, and then your response begins on line 19 and continues on to page 8 and even to page 9. Do you see that testimony?
I do.
I want to focus on the first response that you have to OPC witness Dismukes, which begins on line 20. And you essentially testify there that Dr. Dismukes, was incorrect to testify that Pepco's July 31st, 2020 testimony was the first instance where Pepco acknowledged the extent of the error's impact on historical rates in testimony. Do you see that testimony that I referred to?
Yes.
Okay. And if you look on to page 4 on line 3, there's a footnote 12, and that footnote cites to page 17, line 15 to page 18, line 8 of your April 8th, 2020 testimony. Do you see that?
I do.
Okay. Can you keep exhibit Pepco 7F handy, but please pull out your April 8th exhibit Pepco F and turn to that page 17?
Yes. Give me 1 second.
Sure. Let me know when you're there.
I'm sorry, Counselor. Are you referring to his rebuttal or testimony?
Yes, I'm referring to the reference in footnote 12, which is to the April 8th, 2020 rebuttal testimony.
Thank you.
And page 17 in particular.
All right, I'm there.
Okay, let me wait for your counsel to get there as well.
I'm there as well. Thank you.
Okay, great. So the citation at footnote 12 was page 17, line 15, to page 18, line 8. There's no reference in that passage to an error. Is that correct?
We didn't refer to it as an error here. We referred to it as an issue related to the overstatement of the demand billing determinants used in the rate designs for formal case numbers 1139 and 1150. But, as we've discussed, the idea is that the overstatement of demands is an issue that had to be addressed for the traditional test period compliance filing and the MRP, because absent that, there's a issue with the underlying rate design.
Was there any thought or rationale in calling it an issue versus an error, or is that just the word you settled on?
It's just the word I settled on.
Okay. And then there's also no reference to a time slice or double counting or any of those other factors that we discussed a few minutes ago. Is that right?
Not in this testimony. I will say that I did respond to discovery after the filing of my rebuttal testimony related to the impact of the issue on, or the estimated impact of the issue as it relates to the design of the formal case 1139 and formal case 1150 rates for the applicable classes.
Yes, that's correct. But I'm focusing on your statement in Pepco 7F that Dr. Dismukes was wrong to say that Pepco had not addressed this issue before in testimony, not in a discovery response.
Well, we make note explicitly that it was an issue regarding demand billing determinants in formal case 1139 and 1150. To the extent that they were generally overstated in the applicable test periods, resulting in demand rates that were too low. And we discussed that, we believe, and we've since put forth estimates that this issue has had an impact on the deferred BSA balances for the affected customer classes.
Thank you. Let's focus on that part of your response that you just mentioned, the applicable test periods in formal case 1139 and formal case 1150. That's on page 17, beginning at line 19 to line 20. Am I correct that of the various drivers for this error or the double count, it is the main driver is the time slice where there's a rate change between cases? For example, August 2018.
Yes, the primary time slice driver is the distribution rate change that took place in the test period for the traditional test period compliance filing. Okay.
Do you know what the test period in formal case number 1150 was? And if you don't recall, that's fine.
I don't recall off the top of my head.
Okay. Would you accept subject to check, and we can provide the commission order that it was calendar year 2017?
Okay. I'll accept that, yeah.
Accept subject to check. Okay, thank you.
Check.
If the time slice was, the main time slice was August 2018 after the test period, is any error that's reflected in the test period related to some of those minor drivers?
Could you restate your question?
Sure. Under traditional regulation in the district, rates become effective after the end of the test period because it's a historical test period and rates are effective prospectively, correct?
Yes.
So my question is, if the main driver was the difference between the 1139 and the 1150 rates in August 2018, which was after the test period, would the errors that are reflected in the test period in 1150 be related solely to those other items?
So just so I'm clear, are you asking about the traditional test period compliance filing in this case or the 1150 test period? Because for purposes of this case, the August 2018 time slice issue, okay, affects the actual billing determinants used in the traditional test period compliance filing. So I'm not sure I follow necessarily the question.
Sure. Yeah, this is dense stuff, and I'm sure you understand it better than anyone. So if you're confused, that means I'm not doing a very effective job here. So let's turn back to page 17 and look at line 19 to 20. There you are discussing the billing the issue with the billing determinants in the applicable test periods in 1139 and 1150. Do you see that?
I do.
So that's what I'm focusing on, not the traditional period in this case, but the error that was embedded in the test period in formal case 1150.
Got it.
That error was unrelated to the August 2018 time slice, right? It was those other items.
No. So the issue related to the billing determinant report was present in the design of the demand rates in formal case 1150, in that the billing determinant report was pulling generally overstated demands, and you said, apologize for asking, but you said the test period for 1150 was 2017, in which case there would have been a distribution rate change in August, or I apologize, I can't remember the exact date, but there was a distribution rate change in 2017. So we had the same kind of issue, and that's again where you kind of see the problem arise in that the report returned too many billing determinants, and this resulted in a generally overstated demands being used in our rate design.
Okay, thank you. Yeah, and you're correct. There was a rate change in August 2017 as well. So that would be one of the major drivers, the time slice going into the 1150 test year or in the middle of it. But then the August 18 time slice, that would affect a future period and not the historical test period in formal case 1150.
Well, yeah. So so just to be clear, that the traditional test period compliance filing in this instance is affected by the time slice that took place during the historical test period, related to formal case 1150 rates going into effect. For formal case 1150, its test year had a time slice related to the formal case 1139 rates going into effect. I want to say August of 2017. So it's the same underlying issue for different periods of time.
Sure. That's my understanding, and if that's your understanding, then that's great. I think we've clarified that point. That's what I was trying to get at. You can put away your exhibit Pepco 4F, but again, please keep out Pepco 7F. And at this time, Your Honor, I'd like to mark for identification the response to OPC data request number 61-11, which has been pre-marked as OPC cross-examination exhibit 6, excuse me. I would like to mark it as OPC cross-examination exhibit 3.
So mark.
Mr. Blazunas, can you let me know when you have that document in front of you? It's also on the screen.
Yeah, it could be 1 second. All right.
Okay, the question asks you to describe in detail the steps Pepco has taken since the spring of 2020 to evaluate and assure the accuracy of the data in the demand report or the demand variant report we've been discussing. Do you recall receiving this data request and providing the response in the paragraph below on you received the request on October 6th?
I do.
Okay, great. I want to focus on the second and third sentences of your response, which discuss Sarbanes-Oxley compliance. Do you see that?
I do.
Did Pepco's obligations to comply with the requirements of Sarbanes-Oxley change in any way as a result of this billing determinant error?
Could you rephrase the question?
Sure. What I'd like to know is, did Pepco do anything different in terms of Sarbanes-Oxley compliance, or was this a compliance requirement that you already had and you're just restating it here?
So is the question whether or not there are any specific Sarbanes-Oxley controls around the demand billing determinants? Or,
that was not exactly, but let's go with that one, sure.
Yeah.
Are there any Sarbanes-Oxley controls around the demand billing determinant variant report?
Not to my knowledge. So what we're talking about here is that the data that's being pulled from the reports is in our billing system, and there are a number of controls and including SOX-related controls to which that data and the code used to extract that data are a part of. And those designs and controls are evaluated by external auditors.
Were there any changes to those designs or controls directly related to this error in billing determinants?
So as I discussed in my rebuttal testimony, we have verified that the underlying issue that affected the demand billing determinants does not affect the kilowatt hours or the customer counts used in the company's rate designs. We've also since started a key financial control related to the essentially the verification of the billing determinants used in the design rates. It's essentially a revenue proof, and that is evaluated by our Exelon Audit Services team. So that's kind of a going forward change. And then we also have a number of additional changes we'll be making going forward as well, related to billing determinant verification, comparisons of historical billing determinants versus forecasted billing determinants, and so on.
I appreciate that, but you're jumping ahead of me. I'm focusing solely on Sarbanes-Oxley. Did you start doing anything new with respect to Sarbanes-Oxley compliance and billing determinant errors in the spring of 2020?
I think that's been asked and answered.
I have not received an answer. The answer went to what we're going to talk about next, which is the key financial control, some of the other changes, but I have not received an answer to whether there is anything unique about Sarbanes-Oxley compliance directly related to this error.
I know that there's been questioning about Sarbanes-Oxley. I'm not sure whether or not council has received an answer. I will allow one more time for the council to ask the question, and the witness can give whatever answer that they have.
Thank you, Your
Sure, Mr. Blazunas, again, I just want to make sure any obligations under Sarbanes-Oxley that you had in relation to billing determinants were the same before you discovered this error and after you discovered this error. Is that correct?
So the obligations are the same?
Yes.
To my knowledge, there's been no change in the obligations.
Okay, thank you. Now, you've mentioned the key financial control. Let's focus on that for a second. And I want you to turn back to Exhibit Pepco 7F, if you would, and look at page 11. Actually, page 10, I'm sorry. Let me know when you're there.
I'm there.
Okay. On page 10, there's a question on line 3 that asks about some of these changes that we just discussed, and your answer goes from line 6 on page 10. I want to focus on the part of your response on page 11 that focuses on this key financial control. That's on lines 11 to 14. Do you see that?
I do.
Okay. With respect to the first part of your answer on lines 11 to 13, where you state that the company has completed the key financial control designed to ensure that the company's approved rates yield commission-approved level of distribution revenue. What commission-approved level of distribution revenue are you referring to?
So the financial control is ultimately done at the time of an order in a rate case, and what it's meant to do is to help verify that the rates that have been designed meet the commission approved level of revenue. Our team, however, does, prior to the end of an order, or sorry, when the company receives an order, it executes this key financial control to ensure that the company gets its approved level of revenue based on its designed rates. It'll do that as a part of the process of applying and then litigating the case. So it's something that my team would do both, kind of during the course of the case and then at the time the case has been decided upon. With respect to the idea of the commission-approved level of distribution revenue, prior to the case being resolved by the commission, it would essentially be a proposed level of distribution revenue.
Okay, so with the error uncorrected, the company still recovered the level of commission-approved distribution revenue. Is that right?
So this key financial control would not capture the issue. This key financial control is related to the total level of distribution revenue. The key financial control that's more tied into the billing determinant issue is mentioned on page 12, Part A, regarding the use of, you're essentially checking the reasonableness of the actual billing determinants by comparing how much revenue they produce based on approved rates versus actual booked distribution revenue. And then you're aiming to ensure minimal variances.
Okay, thank you. And the items identified on page 12, those are prospective changes that Pepco proposes to make in the future, as opposed to page 11, which are changes that have been made already. Is that correct? I saw you nodding, but I lost audio for a second. I can't hear.
My remote was hitting the desk, so sorry about that.
No problem. We're almost done. Just
he needs to repeat his answer because nobody heard it.
No one heard you.
Oh, sorry. Okay. So just to be clear, my answer is that is correct. 11 is what we've already done. Page 12 is prospective.
Okay, thank you. Just one last question on page 11. On lines 8 to 10, you discuss this additional step that the company has included where the revenue requirements and the rate design witnesses conduct a joint review to sign off to ensure that they use the same customer counts. Do you see that answer?
I do.
That answer was not identified on your October 6th response that we just went over, the response to OPC data request 6111. Is that a requirement that you put in just before filing Exhibit Pepco 7F?
I want to say that it was put forth in a response to staff DR. It's in set 26. I can't recall off the top of my head which one.
I think you're right. It's the footnote there at the bottom.
Oh, yep. 20. Yep, there it is.
So in this, focusing on line 10, would you be the rate design witness?
I am the rate design witness, yes.
Is Mr. Wolverton the revenue requirements witness?
He is.
Did you perform this review prior to filing Exhibit Pepco 7F?
Yes.
Am I correct that Mr. Wolverton reviewed your April 8th, 2020 rebuttal testimony before it was filed?
Company witness Wolverton would have reviewed it. Oh, sorry, go ahead.
Oh, that was my question.
Yes.
Am I correct that he did review it, your April 8th, 2020 rebuttal testimony before it was filed?
Yes.
And that review did not catch the second error with respect to billing determinants for the multi-year rate plan. Is that correct?
That's true, but I would just make note that so first, two things. So first, that Part C has to do with the billing determinant synchronization RMA that we introduced in Pepco 4F for the original MRP. The rebuttal testimony corrected the actual demand billing determinants in the traditional test period compliance filing, so unrelated to the RMA 25, and then the subsequent issue that arose and was cause for my errata testimony and subsequent filings was related to the need to carry forward the correction to the actual demand billing determinants to the forecasted demand billing determinants used in the MRP.
Okay, thank you. Focusing on these
Mr.
items
Gray?
A through E, excuse me, on
Mr.
Steve
Gray?
and Edward on page 11. Which of these
I hate to-
quality
I hate to
controls would
interrupt.
catch? Yes.
Yeah, I hate to interrupt. I just wanted to give you a heads up that we are reached the allotted time that you had set aside for cross-examination. So I just wanted to give you a heads up that we're at that moment, but how much more time do you need?
This is my last question.
Perfect. Please.
You have good timing on that.
Thank you.
So focusing on A through E on page 11, these quality controls, which of these 5 would catch the time slice error that you identified on page 4 of Pepco 7F?
So which of these items? So A is already basically stating that we're using a corrected version of the demand report to essentially remove the issues related to the time slices. So essentially, now that we have a new corrected report, that is the resolution of the issue.
Okay, thank you, Mr. Blazunas. That is all I have.
Thank you.
Your Honor, I have some follow-up plus a couple of foundational questions.
Please proceed.
Mr. Blazunas, as a follow-up to some of the questioning by Mr. Gray, could you please again turn to the response to 9-2 that was on OPC's cross-examination exhibit list?
Yeah, give me 1 second. I don't think this one's it.
It's the same exhibit that you were asked questions previously.
Yeah, we're pulling it up. Sorry. All right.
Okay. Were all customers in each rate class affected by the alleged double counting?
Not all. So only the customers with demand rate components were affected. And you can see on the next page, the deltas by class.
Are you able to tell me how many customers in each of those classes were affected?
It would depend on the customers who had multiple time slices in the billing period.
Have you calculated the precise numbers in each class?
I've not.
Were billing determinants for both KWH and KW affected?
No. And as I stated in my Pepco 7F, the company verified that the underlying issue associated with the billing, the KW billing determinants, does not impact the KWH or the customer counts.
if KWH and or numbers of customers were not affected, why did the time slice not affect those billing determinant measures?
So the issue with the time slice was primarily related to essentially the coding that would pull this information from the data, or sorry, from the company's billing system. What would essentially happen is within the code for the demand billing determinant report, you had it pull the demands in such a way as it was essentially for customers that had the time slice, it was pulling the information twice, or however many time slices there were. But that is not, we've confirmed that issue wasn't present in the reports for the customer counts in the KWH.
And I believe earlier you also referenced the influence of canceled and rebuild accounts. I heard you discuss that earlier.
Yes, that would be another cause of a time slice for a customer.
But doesn't the company frequently incur canceled and rebuild accounts?
I don't know how often the company cancels and rebuilds accounts.
You have no idea?
Not off the top of my head, I do not.
Have you ever looked at that data?
The frequency of cancel rebills?
Correct. And numbers of customers that are canceled and rebuild?
No, I have not.
Okay. Looking at the attachment to your response to 9-2, we see differences between the actual data and the revised data. But just looking at the attachment, how can we verify that the revised data is any more accurate than the information originally provided?
So, as I've discussed in my testimonies, we identified an issue that was related to the demand report used to pull our KW, or sorry, excuse me, our KW demands. The identified issue, had to do with the double counting, or the overstatement of demands based on these time slices in a period. We've removed that issue, and as I state in my Pepco 7F, there was no underlying issue with the actual data billed to customers over the period. It was simply an issue with how the data was compiled in this report as a result of the coding issue.
I guess my question was, how would AOBA or the commission staff or another party go about verifying that the revised data is more accurate than the initially filed data?
Well, I can tell you that within Pepco 7F, we discuss kind of like a billing determinant verification process related to randomly sampling customer bills and looking at the KW that show up on the customer's bill versus the KW that show up for that customer in the context of the report.
Okay, could you just refer me to that page so I have that page? Where is that?
Give me 1 second. If you go to page 12 of my 7F,
okay,
and then it's starting at line 11.
Okay, yeah, I remember going through this, but that's a forward-looking verification process. That's not looking at the past. Each part C, Pepco will implement, Pepco will provide, Pepco will submit.
Yeah.
I'm asking you, how would a party go about verifying what was initially filed versus the revised to make sure that we have confidence in your revised numbers, that they're more accurate than your initially proposed numbers?
What I can tell you is that we did verify the new demand variant report against customer bills to make sure that it was pulling the demands correctly so that we no longer had the time slice issue.
Okay. I'm going to try this one more time because I don't think you're getting at the heart of my question. You're telling me what you did. You know, at this point in the process, AOBA and maybe other parties don't have full confidence in the work that we're seeing the first time around. So could you tell me how AOBA would go about verifying the revised data versus the initially produced data?
You know, I think at the end of the day, it really comes down to the company has verified the actual demand billing determinants coming out of this variant. And like I said, we did make sure that they were pulling the correct demand relative to what is on the customer's bill.
So it's trust us, we did it right this time, correct?
Objection, Your Honor. She's mischaracterizing what the witness just stated.
Ms. Spencer, can we move on? I believe you've asked and he's answered this question.
I'll move on, Your Honor. I'll move on. Okay. Now, all right, would you please go to, let's see. Just 1 second, Your Honor. I'm just looking through my notes. Okay, could you please refer to 7F, page 2? And Mr. Blazunas, just a review for yourself, lines 3 through 11 on page 2 of your exhibit 7F.
Okay.
Okay. Focus specifically on lines 10 through 11, when you say, according to the Commission's procedural schedule, this second issue is intended to be the focus of the party's testimony. You're referring to the procedural schedule in order number 20632 issued on September 24th. Is that correct?
Yes.
Okay. Are you able to tell me what specific language in order number 20632 did you rely on to assess the intent of the Commission to limit the scope of the October 9th testimony of AOBA and other parties?
So I would refer you to the company's cover letter from October 14th discussing, so the second paragraph discusses what the parties are permitted to provide as a part of the their supplemental testimony in response to the issue.
So that letter was written by Kim Hassan, correct?
Kim Hassan's name is on the letter.
Okay. And that's a letter by an attorney, correct?
Kim Hassan is an attorney.
And that's what you relied on to make the statement on lines 10 and 11 on page 2, correct?
Yes.
Okay. Now, just one more question. I don't know that you need to turn there. Looking at your Exhibit F, your statement of qualifications, I see you have a Bachelor of Arts and a Master's degree in Economics. Is that correct, from the University of Akron?
It is.
Okay. You don't have a legal degree?
I do not have a legal degree.
And this is the first rate case that you've appeared in and testified in. Is that correct?
No.
So let me take a look at I believe you testified in formal case 1130. Is that correct?
No. I've testified in the Maryland jurisdiction rate cases.
Which ones? Which ones?
Case number 9472 and case number 9602.
Is that on behalf of Pepco?
Yes.
And were those both rate cases?
They were.
Okay. Your Honor, I think that's all I have for the moment. Just 1 second, please. Your Honor, I think that's all that I have for the witness right now. I guess at the end of his cross-examination, I will make my motion if that's appropriate.
Absolutely. Thank you. So I believe that no other parties have cross for Mr. Blazonis. Is that correct? Anyone else? All right. The commission I have just one question here. So directing your attention to commission staff DR numbers 26 through 29, I think we have preliminarily marked them as commission exhibit number 37 for the purpose of identification. Do you have that before you?
We're grabbing it right now. 1 second. So we're talking about commission exhibit, 37. So company's response to staff DR 2629.
That's right.
Got it. Okay, I have the sheet in front of me.
Okay.
Oh, sorry. Go ahead.
Yeah, please proceed.
No, I was just going to say I haven't really seen this sheet before, and so I just want to point out that it looks like there are a lot of familiar numbers related to my response to staff 2629, but I haven't verified the totals contained in the sheet or anything like that. So I just want to be clear.
Fair enough. And this is not an exercise in a gotcha moment. So I'm going to ask a clarifying question regarding this. And the area that we're talking about is monthly distribution bill impact. So you state, so in this, we seek the average distribution monthly bill for some selected classes for the MRP years rate year 1 to rate year 3. Okay. Will you accept that? Subject to check.
Subject. Yes. Okay. And so we're, and just to be clear, we're on the.
It's on the screen.
On the screen. Okay.
All right. My question is simply this: we were asking about the monthly distribution bill impact. Can you confirm to me that in your response that you provided the monthly distribution bill impact, or did you provide the total bill impact?
I believe we provided a total bill look. Let me take a quick look. And I apologize, I think probably what happened is the question itself reads, please provide a bill impact analysis, but then the table read residential distribution bill impact. So we did provide a total bill look, but it would not be, we could certainly provide it from a distribution only bill look too.
Please accept that as a bench request that you provide a monthly distribution bill impact look and provide that to us.
Yes.
Right. And that's all the questions that I have, Commissioner Beverly. I do not believe he has any questions. So with that, we will now turn to exhibits. Also, I'm going to mark that exhibit as, I believe, Commission Exhibit number 1. So now we'll turn to the company to mark the exhibit, to move their exhibits into the evidence.
Yes, Your Honor. Thank you very much. I'd like to move exhibit Pepco F as Pepco Exhibit 13. Mr. Basunas' supplemental testimony 2F as Pepco Exhibit 14. Mr. Basunas' second supplemental testimony as Pepco Exhibit 15. Mr. Basunas' rebuttal testimony, which was 4F, as Pepco Exhibit 16. Mr. Basunas' surrebuttal testimony, which is 5F, as Pepco 17. Mr. Basunas' third supplemental testimony, 6F, as Pepco Exhibit 18. And then finally, Mr. Basunas' fourth supplemental testimony, 7F, as Exhibit 19.
Without objection, those are accepted.
Wait, objection, Your Honor, objection.
The chair recognizes Ms. Francis.
Okay. Got to work that mute button faster. Your Honor, what I am objecting to is beginning on page 2, specifically lines 10 and 11. I am objecting to page 13. Lines 5 through 7, where specifically it's in the witness's testimony. This recommendation is beyond the scope of the company's July errata and additional supplemental testimony filings related to the correction of the forecasted demand billing determinants used in the company's MRP rate design, as well as page 15, lines 5 through 8, where the company says in its October 9th, 2020 testimony, AOBA covers a number of topics as discussed below. Arguably, none of these topics is specifically related to the company's errata filing, and many are a continuation of arguments made previously in this proceeding or in prior cases. Those lines, and I am also objecting to Exhibit 7F-28. If I might give very specific objections. First of all, in regard to page 2, lines through 10, Mr. Basunas just stated on the record that it was not his opinion. It was Kim Hassan's opinion. Obviously, I am not permitted to cross-examine Kim Hassan. She's entitled to write a legal letter, but I'm not allowed to cross-examine her. It was not his testimony. I believe it's the same Same objection for the other two, which are also his legal opinion that clearly come from Kim Hassan's letter. The next thing is there is absolutely nothing in order number 20632 that limits the specific issues that AOBA and other parties could address in their October 9th, 2020 supplemental testimonies. Attachment A, procedural schedule, simply states OPC interveners file supplemental testimony on Pepco's errata and supplemental testimony. Witness Oliver's October 9th, 2020 testimony clearly responds to Pepco's errata filings and voluminous supplemental testimony, as well as the content of the related Pepco attachments A through O to Pepco's original supplemental and revised supplemental responses to staff data request 2424, in which Pepco first suggested a need to revise its demand billing determinants. Witness Blazuna offers the legal argument that AOBA's October 9th second supplemental testimony should have been limited to discussion of Pepco's corrections of its forecasted demand billing determinants and the impact of those corrections. Yet the matters addressed by the company's third supplemental testimony and exhibits were far more extensive, including, for example, Pepco Exhibit 6F-21, which has no direct tie to the company's need to file an errata and instead represents Pepco's attempt to provide rejoinder to the discussion of BSA revenues under recoveries in AOBA's June 1st, 2020 surrebuttal testimony. The Commission should also note that AOBA's October 9th, 2020 testimony embodied an effort to substantially respond to Witnesses Blazunas' July 31st, third supplemental testimony, which encompasses over 660 pages of testimony and exhibits. 2, the company's July 28th errata filing, which includes over 250 pages of revised testimony and exhibits. 3, the company's original supplemental and revised supplemental responses to staff data request 2424, which includes at least 15 PDF and electronic attachments, A through O, and 4th, the content of Pepco's September 10th, 2020 technical conference PowerPoint. My next argument is in regard to Witness Blazunas' Exhibit 7F-28, which represents an entirely new analysis using detailed monthly projections of numbers of customers, KWH use, and KW demands going out as far as 2025, where such detailed projections of monthly billing units by class had never previously been provided in this proceeding. In addition, it offers speculative projections of future BSA deferred revenue balances without any attempt to explain how the ongoing impacts of the COVID-19 pandemic were considered. Additionally, Pepco 7F-28 calculations for monthly revenue per customer targets should have been provided previously in this proceeding. In other words, with the company's original enhanced MRP proposals, but were not. Exhibit Pepco 7F-28 represents a belated attempt by Pepco to place additional analyses not previously provided into the record of this proceeding. It does not represent a necessary or appropriate response to OPC witness disputes, call for a new proceeding to investigate the operation of Pepco's BSA, and it constitutes nothing more than inappropriate and unscheduled rebuttal or rejoinder to prior AOBA testimony in this proceeding regarding the company's BSA revenue under recoveries. And finally, lastly, Pepco has previously stated in a data response, which is attached to Mr. Bruce Oliver's testimony. It is in attachment A, which was referred to before by People's Counsel. And in that response, which was dated October 7th, 2020, the company states specifically, Mr. Blazunas states, the company has not done any audit or investigation related to the BSA deferral balances of commercial classes with demand rate components. See also the company's response to formal case 1156 OPC 61-14. So those are my arguments. We believe it is a totally new exhibit. They have not previously provided it. It is with forecasts going out to 2025, and it is not appropriate to put in at this time. Thank you, Your Honor. But I have no objections to the other portions of Mr. Blazunas' testimony. I can't hear you, Your Honor. I'm sorry.
Thank you, Ms. Francis. Did we hear a response from the company?
Yes, thank you, Your Honor. With respect to the various parts of Mr. Blazunas' testimony in 7F to which AOBA objects, I would refer the Commission to Order Number 20632, paragraphs 23 and 24, when it delineates the purpose of having additional testimony and states that additional testimony, if necessary, should be filed on October 9th. Responsive testimony from Pepco will be filed on October 14th. But in paragraph 23, it states, we will allow the parties a further opportunity to, quote, probe Pepco's errata filing and proffer an assessment on the supplemental rebuttal testimony and exhibits impact on the rate application. It goes on to state that any testimony that OPC would like to proffer, on paragraph 24, that OPC would like to proffer on Pepco's errata should be addressed in an October 9th supplemental filing rather than oral presentation at a hearing. Our reading of that of those two paragraphs was that the purpose of the October 9th testimony and the purpose of our October 14th responsive testimony was to address the errata filing and the supplemental rebuttal testimony regarding that errata filing. To the extent that testimony went beyond that, and Mr. Oliver's testimony was the only one that did go far beyond that, we thought it was appropriate to point that out. And if that is the witness's opinion, the witness is the one who was most engrossed in the errata filing in the September 10th presentation. And this is a person who knows this issue best. And so when he said this is beyond what we were talking about in the errata, I think that is his opinion, and he's entitled to state that as part of his testimony. With respect to the Exhibit 7F-28, I have not heard from Ms. Francis before now as to her specific objections to this piece of Mr. Blazunas' testimony. However, I would say that it does substantiate what he was talking about in his testimony. And like all testimony that comes before the commission can give each piece the weight to which it believes it's warranted. So I don't believe that Ms. Francis has established a basis to strike any of Mr. Blazunas' 7F or its attachments. That's all. So thank you very much, Your Honor.
Shall I respond?
Quick response.
Okay. I do not believe paragraphs 23 and 24 open the door for a free-for-all and for new estimations and for new projections. There has been no opportunity, obviously, to do discovery and to verify the numbers on Exhibit 7F-28. I am sure that Your Honor can understand why we are a bit skeptical about data that we see from Pepco. I do not believe that this commission order goes beyond that for more data, etc. Mr. Oliver's testimony clearly, and we set out very specifically before what he responds to. There was a lot of information he was responding to. I set it out in my motion. There were I mean, the volumes go this high, I can't pick them up, or I would try to be a little bit dramatic. There was a lot of information in the July 24th through the July 31st filings. He had to get into it. He had to respond to it. The company complained in Kim Hassan's letter that he had over 70 pages of testimony. What did he think when they're proposing 76% increases in our members' KWH charges? We were going to take this seriously. We worked nonstop on that testimony to produce what would be helpful to the commission. I do not think that we have an opportunity to verify Mr. Blazudis's new schedule. He is not an attorney. He is not qualified to state what was in that order, and that Mr. Oliver's testimony went beyond it. Thank you.
Thank you, Ms. Francis. The commission appreciates the argument from the parties. We will take this issue, we will accept all of the exhibits moved into evidence except for those objected to by Ms. Francis at this time. We will take the objection under advisement, and we will issue an order subsequently before we move forward tomorrow. So with that, moving on to Office of People's Counsel for their exhibits.
Yes, Your Honor. I referred to several documents that will be moved, or that motions will be made later in the week to admit by Ms. Francis and myself. The only document that I have that I would like to move for admission right now is the document that was marked as OPC Cross-Examination Exhibit 3.
And I believe that would be number 3 for you. Right?
Yes, it was pre-marked as 6. It will be number 3. Thank you.
That's right. Thank you. All right, we have Aoba. Do you have any exhibits? I'm sorry, I did skip over you. No, it's Aoba. I'm getting tired, y'all. Okay, Aoba. You're on mute, Ms. Francis. We've done the company, we've done OPC, now we're up to the interveners. First up is Ms. Francis. Take yourself off mute.
Sorry. No, I have no new exhibits. The exhibit I was using had been referred to earlier by OPC. So I just want to make sure that OPC had that in the record. I might not have heard it.
Yes, I believe it is in the record.
Okay. Thank you, Your Honor.
All right. And district government? I believe we have any questions.
Yes. No, the district government had no exhibits for this one.
Okay. All right. In the commission, we had previously marked what was 17 as 1. So we will mark what was previously marked as Commission Exhibit 37 as Commission Exhibit number 2. All right. With that, Mr. Bazunas, you are dismissed. Thank you for your testimony.
Your Honor, just one last thing. Is it possible that we may move more quickly on the list tomorrow, so that I need to tell Mr. Bruce Oliver to be prepared for hearings tomorrow rather than Wednesday?
I believe you have teed up perfectly what I'm about to say right now.
Thank you.
You're always one step ahead of me, Ms. Francis. I believe that this is a great opportunity for us to break today. I want to thank the parties for moving expeditiously throughout the witness list today and actually accommodating one additional witness than I thought we would. This is what I propose. I am giving you, I plan to go till 6 today. We're going to leave early, but I would like for everyone to exchange with the other parties every exhibit that they plan to use on the witness, so that we can finish this proceeding tomorrow. I would like to do so. Would anyone like to be heard? Would anyone like to be heard on that request from the bench?
Your Honor, this is Anjali Patel from OPC. I just needed to note that Mr. DeCourcy will not be available after 3:30 tomorrow. So depending on where he falls in the line, it it may not be possible to get him up tomorrow, but we will try our best as things go forward. Also, as Pepco mentioned earlier, the cross exhibits were to be identified at least 24 hours in advance. To the extent they can get those to us as soon as possible, that would be much appreciated as we're already within the middle of the day. Thank you.
Your Honor, AOBA will be ready tomorrow. And hopefully we will be able to get the cross-examination list for Mr. Oliver towards the end of the day. Thank you.
Thank you. Would anyone else like to be heard? All right. So the commission thanks everybody once again for a very productive day. This is our first full evidentiary hearing virtually done by the commission. And I have to say, it was not without hiccup, but I'm not too displeased. So with that, we will adjourn for today and we will be back on the record tomorrow, 10 a.m. sharp.
Thank you, Your Honor.
Thank you.
The person sitting where it says Miss Kim Hassan, what is your name, please?
That was Miss Bellamy representing.
I'm sorry.
I didn't hear anything at all. Everybody cut out.
I'm very sorry. Can you hear me?
Yes.
My name is Sherry, Sherry. Everyone else has their iPhone, so it's echoing. It's Sherry, Sherry. Bellamy, Bellamy.
Thank you very much. I appreciate that.
Thank you.
Have a good evening, everybody.
You too. Thank you.
Thank you. Thank the court reporter.